Supplementary list, fresh admission, item number 1.
Item 1, my lord, infructuous.
Infructuous dismissed. All right.
Item number 2.
May I please, Your Lordship, in this matter, I have challenged the order in original which is passed beyond the limitation period, Your Lordships. For that, Your Lordship, kindly have a glance at page 16, the impugned order.
Marking is missing.
The proceeding has been initiated under section 73 and the relevant parties, Your Lordships, the first, reply and defend submission of the notice. In response to the impugned so-called notice, the noticee has not submitted any reply so far. And in the discussion, Your Lordships will find that I have carefully gone through the allegations made in the so-called notice dated 30/9/2019 and 16/8/2021, reply to the so-called notice in response to the allegation and submissions made by the noticee during personal hearing, which was never afforded. And so far as these notices were concerned, Your Lordships, for 2014-15, they have issued notice dated 30/9/2019.
Same question. It's an appealable order.
Only on regarding limitation, Your Lordships, kindly have a glance at page 7, the 73(1). What says? The limitation period is page 7 of my read petition. I have quoted that.
All right.
Section 73.
Yes.
May I please?
Yes, yes.
Recovery of service tax not levied or paid or sought levied or sought paid or erroneously refunded. Subclause 1. Clause 1. Where any service tax has not been levied or paid or has been sought levied or sought paid or erroneously refunded, Central Excise Officer within 30 months from the relevant date serve notice on the person chargeable with the service tax which has not been levied or paid or which has been levied, sought paid, or the person to whom such and such. Provided that, then Your Lordship comes the extended period. And when the extended period is will work, that is provided where any service tax has not been levied or paid or has been sought levied or erroneously refunded by reason of fraud, collusion, willful misstatement, and suppression of facts. And they have, even if I take it as suppression of facts, Your Lordship, to that extent, I rely on the judgment by Honorable Apex Court. I have supplied the
No, but you're not answering the question.
This is
This is an appealable order.
but Your Lordship is barred by limitation.
All grounds you can take all those grounds.
The initiation of the proceeding is barred by limitation.
Right.
If when
all
the
those grounds you can take. You can take all those grounds.
Your Lordship may reflect that those orders, judgments at least.
No, I don't have to set out. You say the counsel for the petitioner seeks leave to withdraw the present petition, liberty to file an appeal as provided in the statute in question, which is the Finance Act, right? Anyway.
Yes, Lord.
If such appeal is filed not later than 10th April, accompanied by an application for confirmation of delay, citing the pendency of the present petition as the reason for the delay, it will be considered in accordance with law by the appellate authority. The court clarifies it is not expressed in even the matter. If filed any originals here?
No, they have not given. That is, they have given this order through mail. And no so-called notice I have received.
All right.
Also, appeal for the opposite party.
All right.
I have given that order which has been appealable.
All right. The court clarifies that all the points urged in the present petition, as well as any other that the petitioner may have in accordance with law, are permitted to be raised before the appellate authority. All right.
Item number 3.
The petitioner here is the vice chairperson. He is objecting the process for grant of on-sub license. I'll just show one page, my lord. Page 15. Kindly see page 15, my lord. The office, this very block office where is the vice chairman is 80 meters away. National Highway State Highway criteria is obstructing him. Lots of objections here, lordship will find. I will report. This is their own report. Report of the excise inspector. Now, my lord, before I take your lordship to any other matter, the applicant himself had approached your lordship, my lord. I have given an order passed by your lordship on his writ petition. Kindly see that order. Your lordship has been pleased to direct therein to consider the collector to recommend it to the collector. I mean, give it to the commissioner, then thereafter government. that the course order passed. But what I am trying to tell you, Lordship, is Lordship may direct the commissioner to also give us opportunity while considering. That will end the problem. We will raise all the issues before the commissioner.
All right. But has he been implemented here?
Yes, my lord, I have implemented. The applicant has been implemented here as a party. Opposite part, no.
Oh, recently he has filed a
He
petition.
filed a so that happened.
This will go on till March 31st.
Lord, yes, your lordship will be burdened with all these matters still must.
Let him be directed to appear before the commissioner, and
Yes.
commissioner will consider his objection.
All right. You say the grievance in the present petition is that the objections to the application filed by opposite party number 5 for an on-shop license is yet to be considered. Full stop. The apprehension is that the recommendation could be made by the commissioner, is it? Collector. No, it's still pending with the collector. Or?
No, that by then it was pending. By virtue of your lordship's order, that must have gone to the commissioner.
Because commissioner has been targeted till 1st March.
Yes.
Right.
So it must be pending before
Yeah.
him.
Commissioner may send us further recommendation to the government without considering the petitioner's objection. Paragraph. This court has, by an order dated 15th February 2023, in petition civil 4106 of 2023, bracket Sarath Kumar Panda versus State of Orissa, which was a writ petition filed by the applicant for the said on-shop license, issued directions interior for the collector, Balasir, to send his recommendation to the excise commissioner on or before 22nd February, and in turn for the excise commissioner to send the matter to the government not later than 1st March 2023. Full stop. In terms of the said order, the matter should right now be pending before the excise commissioner. Full stop. Accordingly, it is directed that if not already done so, then the excise commissioner will take into account the petitioner's objections, and after hearing the petitioner on a date to be informed at least 3 days in advance. But actually, between today and first is hardly any time. Because when will this get communicated? When will he hear you?
That is what.
Today is only
3-4 days.
Today is only not 23rd. 6th is there. Time is there. Of
No, Saturday, Sunday, all that
Last
comes.
March.
But lordship can extend the date for the purpose. In this,
Then that amounts to modification of that order without hearing the petitioner of that.
because
case.
your
No, no.
lordship directly.
Actually, let's not have a hearing then. You say we'll take into account the objections of the present petitioner and make his recommendation within the time already fixed by the court. The petition is disposed of. Copies
This
of the
order
order
be
be
communicated to
issued.
the-
Yeah, communicated forthwith.
Lord, may I suggest? I'm sorry, Lord. I asked. May I, sir? Lord, I myself will approach the commissioner instead of fixing a date for me to appearance. I'll myself approach the commissioner. He will give me opportunity of hearing me.
Not necessary, sir.
It's okay.
But there are actual aspects to be brought to his notice. I'll myself approach the commissioner.
Or the petitioner is permitted to appear before the commissioner
Yes.
with a downloaded copy of this order
Yes.
on Monday.
Monday. I am sorry, Lord. I troubled it. Great.
Supplementary list item number 4.
May submit, my lord. Petitioners are the legal heir of one Mr. Ashok Naik, who was working with MMTC at Birdville. While working at Birdville, he has acquired certain land out of his own income, one from one scheduled tribe and another from non-scheduled tribe. After death of the Mr. Naik, his legal heirs are now staying in Bhubaneswar. In order to dispose of that house situated at Birdville, the legal heirs, they have required permission from the Tahsildar Birdville, and Tahsildar Birdville rejected on the point that you are having less than 5 acres of land holding. So in this was challenged before the honorable single judge, and honorable single judge filed writ petition 29645, rejected my petition, hence this up. And this area,
Sir, once the regulations apply, then you have to get prior permission, sir. This regulation applies.
regulation applies, my lord. My submission is that it is in industrial and developed area, and house is there, and I have acquired it. My lord, I am not finding any scheduled tribe person to sell that house. And my opportunity cost is going down. I have to sell it in a throwaway price.
Can't
So
be helped,
that
sir.
is my plea, my lord.
No, you're not challenging the regulations. So the regulations very much apply. The whole of Kionjhar is scheduled area. So you can't escape that. There's no distinction made between urban, rural,
My lord, it is a
agriculture, non-agriculture.
It is a house.
The entire district is a scheduled area. And this is Barbell.
This is a mandatory requirement. So it cannot be ignored. And one thing I want to point out, your lordship may kindly see the cause title. Who is the opposite party number 4? Respondent number 4, rather. I don't know why the petitioners are doing all these things. How the Advocate General is involved in these private disputes.
Why is this done, sir?
This should have been
Somebody else drafted. You did not draft.
No, this should not be entertained at all.
Yeah.
And I pray your lordship may not, but I pray that the petitioner should be imposed with heavy cost for impleading Advocate General as a party to this private dispute.
No, maybe in the writ petition itself we had implemented.
No, writ petition, then what is
In the writ petition, it was there.
what is the fun
In the
in
writ petition, it was there.
maybe,
I have
but
seen-
even if
No, no,
it's writ petition,
So at least there it should have been.
He pointed out. There it has not been objected.
My lord, may I pray for short adjournment? I can give better argument on the issue.
No, nothing at all. So you say that present appeal is directed against an order dated 18th February 2021 passed by the learned single judge dismissing writ petition civil 29645/2019 filed by the present appellants challenging an order dated 30th September 2019 passed by the Tahsildar Barbell in land holding certificate case number 6 of 2019 paragraph. The appellants are members of the scheduled tribe (ST) community and claim to be successors in interest of one Sri Jogeshwar Nayak, owner of plots to an extent of AC 0.030 decibel and 0.050 decimals in Barbell Tehsil, Kionjhar district. Full stop. In order to meet the expenses of treatment of petition appellant number 6, who was the widow of late Sri Jogeshwar Nayak and mother of appellants 1 to 5, they applied for a land holding certificate under the Odisha Scheduled Area Transfer of Immovable Properties bracket by Scheduled Tribes bracket Regulations 1956 bracket Regulations bracket. So this was rejected by the Tahsildar by the order dated 30th September 2019 for the reason that the extent of land was less than 5 acres. And therefore, the proviso to Regulation 3 bracket 1 bracket Roman small 3 is not satisfied. Paragraph. Although it was argued before the learned single judge that the land in question was the self-acquired property of late Sri Jogeshwar Nayak, the fact remained that the regulations applied since the entire Kionjhar district is declared to be a scheduled area. It was sought to be urged that since the land is located in an urban area, the regulations may not apply. Full stop. The learned single judge has rightly rejected this plea, since the regulations do not, in fact, make a distinction between urban and rural areas. paragraph. Once it is plain that the regulations apply, then the conditionalities set out therein for permitting transfer of land have to be met. Full stop. In that view of the matter, the court is unable to find any error committed by the learned single judge which calls for interference. The writ appeal is dismissed.
Item number 5.
I may plead your lordship, my lord. I'm on virtual mode, my lord.
Yes.
Page 17 is the impugned order of the Honorable Single Judge. Short question for lordship is the petitioners are the direct recruitees under the FCI, my lord, and has prayed in the writ application to grant pension under the central pension rules. Now the lordship can be turned to page writ application, page number 28, my lord. Page number 28, my lord, writ application.
Yes.
Filed before the Honorable Single Judge. Paragraph 3. That these petitioners are all the retired direct recruited employees of Food Corporation of India and members of FCI Retired Employees Welfare Association, Odisha. Then your lordship can be turned to counter filed by the state. At page 65, my lord. Filed by the FCI, my lord. Page 65.
65 of the writ appeal or writ petition?
Writ appeal, my lord. I have annexed the counter as well as the writ application. Page 65. On the other hand, the petitioners were recruited directly by FCI and hence...
So you can file a review petition because the single judge has proceeded on the basis that there is nothing to show that you are direct recruits of FCI.
That's true, my lord. That's true.
Ah.
Another document, my lord, I can show your lordship.
No, I'll just note Mr. KP Mishra and senior counsel.
Let them serve a copy. They are not serve a copy of
1 minute, sir. As pointed out from the pleadings in the writ petition that even the opposite party state did not dispute that the appellants were open petition recruited directly by FCI and hence are termed as single quotes direct recruits, unquote. He therefore submits that the observation para 3 of the impugned order that there is no foundation that the appellants have been recruited by FCI is on the face of the order erroneous. Permitting the appellants to file a review petition to draw the attention of the learned single judge to the above pleadings in the WP Civil number 446 of 2017, the court declines to interfere at this stage. Full stop. The writ appeal is disposed of in the above terms.
All right. Obliged.
My lord, my presence for opposite party number 3 may be noted because I have been instructed.
And you
I am for 1, 2, 4. 1, 2, and 4.
Mr. Mishra, just ensure that copies are served on them.
Yes, madam. In the course of the day, I will serve.
Okay.
Item number 6.
May please, sir. Your Lordship, I am for the private opposite parties, my lords.
All right. None appears for the petitioners. Dismissed.
My lords, there are also 3 sub-items. Even if this civil review goes, there are other 3 sub-items, my lords. OJC 1247, 1248, and 1249, which is still pending, your lordship. What has happened? That all the 3 OJCs can be disposed of in the light of the order which has been passed in. These are 4 batch matters: 1247, 1248, 1249, and 1250. Against 1250 order, civil review was filed. Other 3 can be disposed of in the light that the order has been passed in 1250. This is the current petition, my lords.
All right. These 3, you said disposed of in terms of the order dated
26th February 1990, my lords.
26 February 1990 in OJC number 1250 of 1983.
1983.
All right.
I'm grateful, my lords.
Item number 7.
None appears dismissed.
Item number 8.
that this is in respect of the Frongeri in the Kendrapada district of district. The applications are made and recommended by the DLC.
When are those coming up?
My lord, I do not know. Now, your lordship have protected me in IA. And your lordship directed let the decision be taken by CA. But without the decision of the CA, now the authority, local authority want to demolish my Frongeri.
I think the interim order.
Overnight, you guys establish it.
Overnight can
Virtually, you know, in that Frongeri matter, you have been seeing those videos.
That is video in Chilika, my lord. That water bodies are there, they are creating. But here, my lord,
they're all experts now. Experts. It's coming up on 15th May.
Your lordship protect me. Your lordship issue.
It's okay, sir. You will set it up in no time. We'll just issue notice, you accept notice and let you come on 15th May with the Frongeri matter. All right.
But protection, my lord, interim protection. My lord, I will not cultivate till that decision is taken, my lord. What your lordship is given the status quo order.
It's okay, sir.
That order may
now and May, let them go ahead and do whatever. Let it be. You can always set it up.
Your lordship has already granted status quo order, my lord, in IA. Let that continue, my lord.
In this case?
Yes. That IA. I have given the IA.
This is for the first time it is.
No. Read petition is the first time, but IA was intervened in the main case. That is there, my lord.
That I have to check because in this so far
IA number, my lord, I am giving, my lord.
It is for the first time it is.
My lord, IA number, I am giving IA number. IA number is.
Let him take instructions then.
I will take instructions.
My IA number is.
Counter on that date.
5364 of 2022, my lord.
All right. Notice. It takes 6 type of instructions. List on.
That IA is not arising out of 3397, I think.
No, arising out of 7469, main case.
Okay, that's 7469. That is posted to 15th May. That we will respond on that day.
Till then, status quo as you will also directed.
Order be passed. That is not in the list today. How can he press for any order?
No.
In that IA,
that is not in that case. They are in that IA. Your lordship directed to maintain the status quo.
Then it will be taken care of. If that
decision is taken by CAA. I pray, my lord, now they are taking the attempt to demolish my Frongeri.
My lord, if there is a status quo order,
you show them status quo order.
Yes.
15th May.
I can utilize that status quo order, man.
That goes without saying. Goes without saying.
You don't be told all that. 15th May.
Or no interim order in this case.
Item number 9.
May I please, my lord? My lord, here it is a PIL, my lord. My lord, the petitioners are villagers. They have filed that 3 to 23. Say opposite party 3 to 23 have enclosed a smosan and also Grama Jungle.
Representation. You made representation.
Annexure 2, my lord. To the Tahsildar, opposite party number 2.
All right. The petitioner's representation shall be put. So, 15/7/21, you made a representation.
Yes, my lord. That has not been disposed of, my lord.
No, but you make a fresh representation. It's better you make a fresh representation.
That has not been disposed of. In continuation to that, I shall file that one, another.
All right. The petitioner is permitted to make a fresh representation to the authorities. If such a representation is made not later than 3rd April, then it will be considered. It will be examined and after hearing the petitioners as well as opposite parties.
3 to 23.
3 to 23 and giving them hearing. The reasoned order shall be passed not later than 8th May and communicated to the parties within a week thereafter. The court clarifies it as not expressed in it. All right.
Item number 10.
Lordship, my representation at Annexure 1 series, 10th January, 19th January 23, it may be disposed of by the Chief Secretary, Lordship, because genuine issue of District Kalahandi, Lordship, for cotton growers, Lordship, is a spinning mill. It's the fate of the Kalahandi, Lordship, enter the cotton farmers and
It's to be practicable, sir.
Lordship.
It has to be practicable to give you hearing and all of that.
That's the only decision taken by the
things to do.
Only decision is taken to the state government, Lordship. That is there. Lordship, they will only improve upon the Lordship, the infrastructure. Because enter fate of the Kalahandi is there, Lordship.
Let all Principal Secretary, Department of Agriculture.
Lordship, as a Lordship, yes.
the petitioner's representations, bracket annexure 1 series, will be examined by the Principal Secretary, Department of Agriculture, HTNH, Government of Orissa, and after notice to the petitioners and giving them a hearing. A reasoned order should be passed not later than 8th May and communicated to the parties to the petitioners within a week thereafter. The court clarifies it is not exhausted.
Obliged.
A copy of this order be sent to the Secretary, Agriculture Department forthwith. All right.
Let's.
Item number 11.
The correction is carried out as pointed out. All right.
Up to 17, 11, 12.
11, 12. Yeah.
Up to 17.
Yeah.
Item number 18. Supplemental list item 18.
My lordship, I seek one last chance to remove the defect, my lords.
All right. This is 2016 matter, sir. Where's the question? No.
One last chance, my lords.
No. This is a petition of 2016. Defects have not been removed for over 7 years now, or for over 6 years now. The court therefore does not grant, is not inclined to grant any further indulgence. The revision petition is dismissed. Yes.
Item 19.
Correction carried out. Yes.
19 and
As
20.
pointed.
20 also.
20. Yeah.
Item number 21.
May I plead your lordship? My lord, question at page 5, my lord. Question of law, my lord. Capital C. Whether there was any scope for estimation of the sale figures, particularly when PDS kerosene were sold, stock whereof had been verified by the Civil Supply Department.
This is high estimation.
My lord. My lord, the tribunal has not given any finding in this respect. So my most respectful submission, let the tribunal rehear the matter.
No evidences have been produced before any of the forum, your lordship, regarding this. If the specific guidelines, the specific findings are there. No evidence has been produced.
So right from the beginning, that
Your lordship. Your lordship.
so even the assessing authority has no evidence to just make an estimation. That's all.
Your lordship, the assessee, in order to claim the expenditure, the assessee has to produce the evidences.
No, that's true. But then in that place, suppose you suspect that he's not done, you do a guesswork. That's the whole problem.
Your lordship, your guesswork is not there. Your lordship,
so you've taken 2 years to apply for a certified copy.
My lord.
The copy of the tribunals, the decision of the tribunal is 6 January 2015.
Your lordship.
But you applied for a certified copy only in December 2017.
My lord, tribunal copy is with me. I'll find.
No. The day you applied for certified copy, just see that. Okay. Page 14. Come to page 14. Date of application for copy 7/12/2017. It's already time barred.
The tribunal order was not served on me. That is why I made application for certified copy of the
I did not give you. That's why. Otherwise, this revision petition is time barred. How come limitation did not point out?
Yes, he would have shown it as service.
No, but
Received on that is.
No, stamp reporting has to be from the date of the order. It's really time barred. No. You see, the stamp report is erroneous in the present matter. A fresh stamp report, because the date of the order of the tribunal is 6 January 2015, whereas certified copy was applied for only on 7th December 2017. Stop. The correct stamp report will be prepared and placed before the court by the next date. List on 9th March.
My lord.
Okay. He has stated the date of receipt of order of tribunal.
8. Correct. That's correct. So he said no delay. Ignoring when the tribunal passed the order.
Item number 22.
My lords, item 22 and 23, my lords. It is IBC matters.
Correct.
My lords, connected matters are coming on 11th April.
11th April. Your lordship, no, your lordship, there is a bunch of matters.
All right. 11th. Okay.
Of the petition also.
All right. List on 11th April. All right.
My lords, give the list of
Item number 24.
My lords, item 24, I have filed IA. My lords,
Two first appeals were involved in this case, my lords.
Acha. Correction be carried out as pointed out. All right.
Para 3, I have stated the case number.
Right. The OVT appeal number has been omitted. All right.
My lords.
Item number 25.
25, my lords. My lords, two questions are to be answered, my lords. One is whether the tractor fully is a motor vehicle, which has been answered by my lordship in Lakshmi Govinda Agro case. And another is, my lords.
No, 1 minute. This tribunal's order is 24 June 2017. And when did you file this STREV? 4th February 2018.
It is within the time, my lords.
No. When did you apply for? When did you get a copy?
No. Memo attached to this order. That's not filed.
So when did you file? There is a delay, sir. The date of the impugned order is 24 June and you filed it only in February 2018. No? Yes. Filed it on 8th February 2018.
That reason in the cause list, there is the date of receipt has not been mentioned in the.
So it must be in the tribunal's record. The memo he has not filed. You should have filed the memo.
The last
attached to the pre-copy of the tribunal's order.
All right. Last opportunity to cure the defect pointed out.
My lords.
List on within a week. List on 9th March. Right.
So here put up for SR after the date of receipt, the impugned order is filed.
Correct.
So that is why stamp reporting is not done.
Item number 26.
May I please your lordship? Question number at page 6, my lord. This is covered by case of automobile. All the questions, sir. All the questions, sir. My lord, your lordship may kindly see para D of the question. Whether the order of assessment under section 43 of the OVT Act is maintainable in the eye of law, particularly when no order of assessment under section 39 or 42 of the OVT Act has been passed before initiation of proceeding under section 43 of the OVT Act.
B is sufficient.
Admit the following question is
B is
maintained, frame D. And then you say in view of the judgment, this court in case of automobiles, the question answered in favor of the petitioner dealer and against the department. The revision, the impugned order of the tribunal, corresponding orders B. AC, ST, and AO are hereby set aside.
Deployed.
Item number 27.
The correction we carried out. Right.
Item number 28.
Lordship, this matter can be taken up next week, Lordship. It's not engaged Mr. B.K. Made. He is not feeling well today, Lordship.
Counsel for the petitioner is to be unwell. 18th September.
Item number 29.
Correction carried out. So many mistakes. Everywhere revision review.
30, 31.
My goodness.
No.
Item number 32.
Wait, please, Milas. Lordships in the last order, Milas are directed to remove the defects, Milas. But Milas, the defect pointed out by the SR Milas, Annexure 1 and 2, they are not impugned Annexure Milas. Milas, this might have been occurred due to no dispensing application has been filed, Milas. Milas, until Milas ignores this defect, Milas.
Why can't you produce those annexures?
Milas, we tried.
Then you have to file an application for amendment.
And for dispensation, Milas.
Yes. Last opportunity to clear the defects before the next date. List on. April.
Deep replacements. Milas, next item is the same, Milas.
Yeah, same.
Item 34. Item number 34.
Commissioner Central Access.
None appears. Dismissal on prosecution.
Mr. Sumant, I think he's not been interested.
Yeah, it's all right. Then whenever they wake up, they do it.
Item number 35.
None appears.
May I please?
Oh, sorry.
I'm sorry.
Sorry.
So we are appearing after the demise of.
Yes.
Here, my lord, in spite of the fact that we have already filed our pardons.
All right.
In this particular matter, my lord, is relating to a collection by the Vigilance Department, my lords. Here, my lords, all the materials were there with the vehicle, my lords. And unfortunately, my lord, it was intercepted on the way, and tax and penalty under the OVAT and the OET Act was considered, my lords. If your lordship would appreciate, my lord, the tax invoice at page 23, my lords, showing the quantity of goods being moved. And your lordship would appreciate that it is an interstate movement, so 2% CST was being charged, my lords.
Let your lordship is notice may be issued, I'll file counter your lordship. Because already tax has been paid.
The entire
Your lordship, it is against the revision order, your lordship.
All right. Notice, he accepts notice for opposite parties and states that reply will be filed within 8 weeks, rejoined for the next date. Yes, on 30th August, 30 August.
Extra copies be some.
Yeah. All right.
So we were expecting before.
Yes.
Obliged, my lords.
Item number 36.
My please, Lordship, this is matter regarding payment of tax liability using credit ledger, your lordships. Yesterday, item 66, your lordship has passed order in WPC number 5642 of 2022.
Correct.
Your
Same
lordship, here.
Already I have given the circular I have given.
All right.
Your lordship, that circular, your lordship, pursuant to that.
Easy.
Here, your lordship, the notices have been challenged in the writ petition. And during pendency of the writ petition, your lordship, order under section 73 has been passed. And against order under section 73, the petitioner has filed an IA.
Yes, it is already in record. It is already in record.
Only I am clarifying the factual question. So far as the in the IA, the 73 order has been challenged. So your lordship, that 73 order may be set aside to the assessing officer to pass a praise order pursuant to this.
All right.
Your
What about the main matter?
Regarding implementation of credit, already I have paid, annexer. Kindly have a glance at page.
main matter against the notices.
Yes. May I please?
Yes.
Kindly have a glance at page 17.
Supporting your cause.
So
Supporting your cause.
Once you pass the order in the IA, the main matter will not survive.
Yes.
All right. You say, during the pendency of the present petition, the CT and GST officer, Jashpur Circle, has passed an order on 29th March 2022.
No, your lordship. Yes, your lordship. Yes, sorry.
For the tax period July 2017 to March 2018, not acknowledging the payment made by the petitioner using the electronic credit ledger, bracket ECL. Paragraph in view of the circular dated 6 July 2022 of the GST policy wing, Department of Revenue, Government of India. It was incumbent on the CT and GST officer to accept payment by use of ECL. Full stop. On that short ground.
Payment of tax only.
Payment of tax using ECL. On that short ground, the order dated 29th March 2022 is set aside and the matter is remitted to the CT and GST officer Jashpur Circle for a fresh order to be passed after taking into account the aforementioned circular of the GST policy wing. Paragraph. The IA is accordingly disposed of. In that view of the matter, the main writ petition does not survive and is accordingly also disposed.
Lordship, already have paid more than the tax demand. So that may be, that may be also, I will ask that point also.
It will be open to the petitioner to point out to the CT and GST officer that the petitioner has already paid in excess of the demanded tax.
Oh, bless you.
I may be pardoned, my lord. I'm sorry. Item 34, my lord. I was on my way. Item 34.
Tell us. Steps for limitation not taken.
My lord. May I pray, Lordship, may I keep the question of law open, my lord, because I have not taken steps.
All right. Counsel for the appellant. It is noticed that the appellant has not taken steps to even file an application for condition of delay, although more than 2 years have elapsed since the filing of the appeal paragraph. In the circumstances, leaving the questions urged, the present appeal open for consideration in some other appropriate case, the appeal is dismissed.
Item number 37.
Also, item 37, 1 week may be granted to remove the defect.
Not, sir. We've already adjourned it only for this.
Lord, first time it was listed, Lord, Annexure 4 has not been filed in attending, Lord. That is the main.
All right. Last opportunity to remove defects for the next date. List on. March. 22nd March, sir. 22nd March.
Item number 38.
May it please, may it please, my lords.
Yes, please.
My lords may kindly see Annexure 3. A return was filed for the assessment year 10-11, claiming exemption under section 51C of the IT Act. 51C is regarding a crew who is in the Indian ship for more than 6 months in a year. That will be exempted so far as Income Tax Act is concerned. Then, my lords, what happened, my lords? My total income 32 lakhs, I claimed exemption. Now that was processed. But a demand alleged to have been raised to the tune of rupees 11 lakhs. Now this I came to know under Annexure 6 at page 25. Lordship may kindly see when an intimation was given. Lordship may kindly see. Intimation under section 245 of the IT Act. Please refer to the return of income filed by you by so and so. Your return has been processed. The refund determined will be adjusted. Then when I came to know that a refund has been, so far as 17-18 has been adjusted, then my lords, lordship will kindly see, I made an application for rectification that is at Annexure 7, page 27. Lordship may kindly see it. This is reference to the assessment of my income filed for the assessment at 10-11. I have come to know that the amount of rupees 32 lakhs 76,515 has been made taxable and demand of rupees 11 lakh 66,000 has been uploaded at your end. However, my submission regarding disagreement to the demand raised would be as follows. Now, this is an application under section 154 of the IT Act. Next, your lordship will find that is Annexure 11.
Let Mr. Chivanka, you reply.
Yeah, I reply.
Now,
let him reply. Notice.
Now what
the
is
first time?
Yes. Now, what has happened? Just 1 minute, my lords. May I take your lordship? Only 1 minute. Lordship, may I kindly see? I paid under Annexure 12. I paid it, and Challan is there, my lords.
So the demand now,
9 and 10.
Now they're demanding 9.4 lakhs.
Yes. Now, my lords, Annexure 10, page 46, I have paid to avoid interest. Now, Annexure 11, just may I take your lordship? Only I read the paragraph, what the ITO Khudda writes to the ITO, Deputy Commissioner International Taxation. Just, lordship may kindly, I am to intimate that the above assessee has filed a rectification application on 9/10/2018 for rectification of the demand on the ground that he was a non-resident during the assessment at 10-11 and his income is exempted under section 51C of the IT Act as the original return of income filed in this office on 28th of May 2010 could not be traced could not be traced, my lords. No action has been taken till date. However, taking into account photocopies of the ITR, well, now they prepare the file and ask them from my documents, and they, yes, you know, prepare.
Anyway, we'll see.
Now, Annexer 1.
Give you interpretation. You say notice, he accepts notice and states that he'll file a reply within 8 weeks, rejoined up for the next date. Less than 31st August. Till the next date, there will be no coercive action taken against the petition. All right.
Item 39.
Name of Chimaka may be recorded.
Yes.
Yes, sorry.
Let's say I have already given the order. Like item 2, your lordships.
Oh, applicable orders.
Only date will be changed.
All right. 30.
The Lordship, I am applying for opposite party number 1 and 2.
All right.
Item number 40.
May it please, my lords. Lordship will kindly see Annexer 4. My lords disposed of allowed the writ petition by directing the revenue to restore the old number and allow the petitioner to file Tran 1. That is, my lords, at page 37, and the operating portion is at page 44.
But this is appealable order, sir.
My lords? No. My lords, just a minute, my lords. I'll now a miscase was filed. That was in the guise not to comply the order. Annexer 5. Lordship may kindly see. Annexer 5 was also disposed of by my lords at page 45. Then, my lords, Annexer 6 at page 47, they allowed me the restoration and allowed me to file Tran 1. I filed the Tran 1 application under Annexer 7 at page 48. Now, a letter was issued that you file, come and file your documents. I also complied it. Now, my lords, the Tran 1 application was rejected solely on the ground that preceding 6 months, at that time I was not having any registration TIN number. How can I file the VAT return? And this is page 31, my lords. They said that no. So the entire exercise is to defeat the lordship's order. Entire exercise.
No.
And that day, on Monday, your lordship's direction, I saw the copy, and your lordship said, Mr. Pradhan, to take instructions. On coming last
your
Monday.
lordship, so far as the compliance of your lordship's order, your lordship's order after the clarification IA, disposal of the clarification IA, your lordship, that has been complied and his RC has been restored and he has been allowed. Now, your lordship, so far as the factual position, this disposal of Tran 1 application is appealable, your lordship, because many facts have to be seen. For that reason, the petitioner may be directed to file appeal against this rejection of the Tran 1, so that the appellate authority can verify, your lordship, many criteria, because as per section 140, subsection 1, many criteria are there in order to avail the, so far as the Tran 1.
That is not the ground where this has been rejected, my lords. Just a minute. Your lordship may kindly see. He is making a twist to get rid of the rigor, because they have not complied the order. This is a very easy twist. Appealable order.
My lord says that your lordship's order has been complied by allowing to file one and
touch the you can, if you cannot touch the nose here, you have to round it. Here I am touching the nose. So this is the what I pray, my lords. This is time and again, and I have made an affirmation, my lords, that the IA, I have filed the hard copies. And what they say, just a minute, my lords. What the lordship may kindly see, that is page 32. The authorized person of the registered dealer states that he has filed annual return of the overt act for the period so and so, claiming SGST credit to the turn one, and it was not carried forward, which was granted with effect from 8/6/2017. The registered person did not file returns. How can I file return? So I filed, the portal did not allow, and I have to file hard copies. You take instruction.
You come to page 47. Last line of that body of the new RC, wherein tin
has been cancelled.
The new RC 47, are you seeing?
Your Lordship, what happened
the
in
new
this
RC,
Your
you see, the new RC being tin is erstwhile VAT, has been cancelled with effect from 2022.
Your Lordship, what happened here?
VAT RC, how can it be?
That should have been cancelled retrospectively from the date when this RC has been effected to. Your Lordship, that is right. But since on that date, because what happened here, Your Lordship.
VAT RC, how can you cancel it with effect from
2022? Pursuant to the direction of this Honorable Court. Why, Your Lordship? A previous original RC was there. That original RC has been cancelled. Against that, he has filed a revision petition before the revisional authority. During pendency of that application, he has applied a new RC under that act. A new RC has been allocated to him. And again, a new RC, he has filed some return but not disclosed. Only nil returns have been filed so far as the new RC is concerned. While the new RC is there, the revisional authority has disposed of the revision application.
That is gone now.
Lord is asking.
Yes.
Clarifying. I'm clarifying.
Let him finish.
The factual.
Yes.
So during pendency, that new RC was active. And at the time of the revisional authority has disposed of his revision application by saying that the cancellation of that original RC, old RC, was not valid. Hence, he has restored. And that restoration order was arrived to the registering authority. But while that has been arrived to the registering authority, at the time GST Act has come into, that is in the year 2018. So at that time, the registering authority has stated that since one RC is active against his name, so the previous RC cannot be restored. Against that, the petitioner has filed the writ petition before this Honorable Court. And this Honorable Court has clarified that you have to surrender your new RC and the old RC will be effective, Your Lordship. So retrospectively, Your Lordship, against we have filed one IA for clarification of that order. And Your Lordship,
when the Act itself ceases to be effective from 1/7/2017.
Your Lordship. So, Your Lordship, since it is a rejection, my respectful submission, because many facts have to be seen. Your Lordship, enter records have to be verified. So
you are determined not to comply at any cost.
No.
Yes. You will see. Just your determination is you are too adamant. We will not comply, and that is why you filed an IA in the month of March. Yes, you filed the IA. Why? You filed the IA, not that this order of the High Court is not workable because the portal will not accept. And Your Lordship, by relying on the judgment of Ramdat Sharma versus State of UP, that once the writ petition is disposed of, no further IA can be filed. On that ground, Lordship allowed dismissed the miscase. Immediately
complied.
You have not. Then you ask, all right, you file kind one. Let us see, you will reject it on some other ground. This is palpable, my lords. This is on telltale. File a counter.
There cannot be.
Yes, I have made amendment. This amounts to overreaching the order of the Honorable High Court. Time and again, you are doing this.
And against
And for last 2 years.
Somehow against also there was a demand. Your Lordship,
A demand has been
in the new
no appellate authority has Yes, yes.
Your Lordship, many facts are to be seen, Your Lordship. It is not so easy, Your Lordship. My respect to with a great respect, Your Lordship. Because in the original, in the new RC, he has filed GST Plan 1. Your Lordship, there he has claimed and the demand is there. Exactly that
demand has been already set at naught. This is the new demand you have created.
In order to overcome that demand.
But
yes.
Mr. Rai, why can't you file an appeal?
No, Mallers, the thing is that this is a very delicate thing, Mallers. Very, very delicate. It lies on a very narrow compass, Mallers. This is the method. This is just nothing but arm twisting method.
Oh.
Yes. Somehow or other you will frustrate the order. What I pray most humbly, Mallets, let a short date may be fixed, let them file a counter and let the records be produced. And your Lordship may kindly see. What is the meaning of this order, Mallets? Your Lordship, just a minute.
It is a factual aspect.
Yes, it's nothing.
And even Your Lordship, my time bound the appeal disposal. And again, it will come here.
No.
The tribunal is not there, but many facts, Your Lordship.
Yes, tribunal is
difficult to produce and to establish enter the
No. Your shouting will not help.
No, mine.
Yes, you are shouting too much, but without any effect. Lordship will see that order of this Honorable Court, my lords. Annexure 4, page 37. It starts, and how your Lordship disposed of the writ petition.
Your Lordship might have remembered that I have tried my level best to save Your Lordship at that time, Your Lordship.
That is why you filed a miscase that that the work order is not workable. Yes. Lordship may kindly see page 40, para 8. The above submission have been considered. The case of the department is that the cancellation of the petitioner registration certificate issued originally under the OVAT Act came about since the petitioner failed to file returns. The case of the petitioner, however, was that because of the cancellation of the registration certificate under OVAT Act, he was not able to file returns and therefore was compelled to obtain a new registration. Be that as it may, the next part, the fact remains that the petitioner did seek legal remedies against the cancellation of the old registration cell number. His revision petition came to be allowed on 17th of September 2018 by the opposite party number 2. By that order, the old RC was under the OVAT Act and restored, and the further consequential restoration of the RC under the OST and CST Act, if any, also issued. The fact further remains that the above order of the revisional authority was not implemented by the opposite parties. This is what has ultimately led to the petitioner approaching this court for relief as noted above. The counter affidavit of the department states that the order of the revisional authority, although not challenged by the department, Lordship may kindly note this.
Reply be filed within 4 weeks to join for the next date. 16th May, sir.
Matters. 16 May, and then also stay matters. No coercive action.
Where is the
application number? No. Just a minute.
Instead of Tramon.
No, there is the demand.
Mr. Rai,
don't want Mr. Rai. You're
Respect my Lawrence in your voice is more than me.
All right. There's no application, so forget it.
Well, this case has not come because of the scanning at the center. The number is minus IA number 2525 of 202.
Notice on that also.
That's notice, yes. Notice maybe. Well, as he's coming with such big guys, I'm really afraid.
You're bringing out the best in him, sir.
And sorry, in item 38, extra copy may kindly given, sir.
All right.
That's it.
I don't know.
I received how many copies? I've given you 4 copies.
All right.
Item number 41.
My lord, some defect have been indicated that will be removed by next week, your lordship.
All right.
Your Lordship, I'm sorry. Your Lordship, here the STREB may not be maintainable because it is this STR revision has been filed against the Somotor. What happened? One assessment order was there. Against that Somotor revision order.
Let him cure the defect anyway.
79.7.
Let him cure the defect. I think he has to file a writ petition.
Your Lordship.
He has given you advice, sir. So up to you what you want to do.
Lordship, section 79.7 is quite clear.
That is appeal, not STR.
Commissioner.
Against that commissioner's appeal order, here writ petition is maintainable, not revision. Sales tax revision is only maintainable against the tribunal's order.
78.
Section 70.
I'll remove the defect. I will address your lordship.
Mr. Jana, if it is 78 order under section 78.
Yes.
So best is to withdraw and file a writ petition.
You take section 80.
80 is against 70.
80.
Section 79, section 7B. Kindly have a glance, your lordship.
Read it.
78 or
if the order passed by the authority subordinate to the commissioner, the revision can be filed to the commissioner.
no,
The order of the commissioner.
you take section 80.
Yes.
It is 78 or 78A, capital A. That is advance rulings.
That is maintainable, but revision is not maintainable. That is, it is maintainable.
All right. Counsel, the petitioner seeks leave to withdraw the present petition, liberty to file a writ petition to challenge the impugned order of the commissioner in accordance with law. Disposed of is withdrawn, liberty is prayed for. All right.
Item number 42.
My lord, in item 42, your lordships, the petitioner formulated one question of law, your lordships, that the constitution of audit team under section 41 of the OVT Act, read with rule 43 OVT, in absence of the assistant commissioner, is the invalidated one, and the consequential proceedings thereof are also invalidated one. This is already upheld by this has been held by my lords in the order of my lords in the case of.
All right. It's a notice, 1 minute, notice returnable. August.
Obligement. Item 43.
My lord, item 43, I may be permitted to file the additional question of law lordship on that issue.
All right. Same, notice returnable, same.
Item number 44.
Obliged.
May I please be questions of law at page 7 minutes. Lord, I'd only humbly pray, my lord, your lordship may kindly admit question number A, B, and D, my lords. The first question, my lord, A is whether the tribunal is correct in confirming the audit assessment regarding lesser payment of admitted tax undisputedly when the AVR accepted the late payment of admitted tax, showing that to be paid as nil, particularly when the assessment is undisputedly an audit assessment and the assessing authority is obliged under the statute to make the audit assessment on the basis of the materials available in the audit report and cannot travel beyond the materials available in the audit report. B, my lords, whether the assessing authority or the tribunal.
I think A has been answered against you, I think.
No, my lords.
33.4. Section 33.4, 33.4. Once the audit visit notice has been issued.
You don't have to be confined only to that. You could find out anything more.
May I just humbly pray, my lords?
No.
If your lordship would take up 33.5, my lords. The period is, my lord, 1/10/2010 to 31/10/2012. Your lordship would get it at Annexure 2 at page 23, my lords. Lordship has marked the period.
Yes.
Then your lordship may kindly turn to page section 33, my lords, subsection 5, my lords.
Yes.
Lordship got it, my lords?
Yes.
Your lordship just come to the proviso, my lords. Provided that, may I just place it, my lords?
Yes.
provided that no such voluntary disclosure shall be accepted where the disclosure is made or intended to be made after receipt of the notice of for audit under this Act or as a result of such audit. So this or as a result of such audit has been omitted with effect from 1/10/2015. So or as a result of such audit, my lord, in my humble submission, would go much beyond the submission of the audit report, my lord. So that is the difference which would not protect me from your lordship's order, my lord. But this order period is 1/10/2010 to 31/10/2012. So this amendment, my lord, at the deletion, my lord, of or as a result of such audit is with effect from 1/10/2015. So this is a much prior period where this particular
receipt.
Exactly. Here I think contrary. More.
You have made that law. That is why you have deleted.
That's and the full bench of the honorable tribunal, my lord, learned tribunal, my lord, has interpreted this and said that this can extend to the time when the audit assessment itself is being taken up. Because or as a result of such audit will not give them that liberty to restrict me to the submission of the audit report.
All right, notice, yeah.
Lords, I'd frame laws for A, B, and D also, Lords.
Your lordship, that is consequential penalty.
All right.
I have a very...
All right, admit the following questions are framed for consideration. A, B, and D.
Lords, in this case, my lords, I have a very humble prayer, my lords. There's an interim application. If your lordship would kindly turn to page 23, the tax demand is around 20 lakhs, my lords.
So your
lordship may permit me, my lord, to pay 50%. I've already paid some amounts, my lord. Pay 50% and stay the balance.
All right.
Of the tax.
Of the tax.
Subject to the petitioner paying 50% of the tax demanded within 4 weeks, there shall be no coercive steps taken against the petitioner.
Not any
during the pendency of the revision petition.
Not
The
any,
IA is
any amount paid in the meanwhile can be adjusted now. For this.
No. Your lordship,
50% of the tax demand said no.
That includes that, your lordship. Because it is a revision petition. So the petitioner should have deposited 100% of tax.
No, I have not.
100% of tax, your lordship may stay the pen so far as the penalty, your lordship.
But I'm paying 50% of the tax. This is my learned friend, my lord, he raised a contention of 33.5 being against me, my lord. I have demonstrated with your lordship, my lord. I have time.
Law is against you.
Only over and above.
All right.
Yes.
Yeah. Payments already made shall be accounted for while computing the 50% amount.
Greatly obliged.
IA 16 is allowed, that exemption.
I may pardon, my lord.
List on 31st August.
The other application may also be disposed of. That was for dispensing with certified copy.
Yeah, which is allowed.
Obligement.
I may pardon, my lord, in item 42, I may be protective of lordships because this is a public sector undertaking of government of Minister of Defense.
Is there an IA?
Yes, the IA, my lords.
There's a notice on that IA. That's notice on that IA and dispense with is allowed. All right.
Your lordship, in item number 41, your lordship have given me liberty to file a writ application. Original order may kindly be returned. So
all right. The orders be returned subject to being substituted.
Item number 41.
Yeah.
Item 45.
Your lordship, that 50% under peculiar circumstances because it may not be in other.
Nobody's going to treat all this as specific. Yeah.
My lords, item 45 is a audit assessment and head of the audit team has initiated the assessment proceeding, which is not permissible.
Copy name.
All right. All right. Notice returnable 30th August. Right. EX.
Item number 46.
Let's say give one time to remove the defect.
Copy maybe not served.
What's the matter about?
It is relating to custom duty refund as per the order of the Honorable High Court of Orissa. And this Honorable Court has ordered that by virtue of the section 13 of the Custom Act, that
they have not passed any order in your refund application till date.
They have rejected refund.
Where, by which order?
The annexer for
this there is no annexure 6. for the sestat.
No, because the OP number 3, the appellate authority are directed to remedy available under 226. That annexer 6, para 9.
No, he might have said that, but don't you have the appeal provision before the sestat against the first appeal order?
This first appeal order saying that you remedy.
No, he might have said, but have you examined whether you have remedy before the sestat?
Because the first appeal order directed remedy available to 226, we approach the Honorable High Court only. Because the Honorable High Court has declared violation of Section 14 of the Custom Act.
Which page? Which page? Which page?
Annexer
which page he has said?
Annexer 2, last 42.
That is this court's order.
Honorable this court only.
No, I don't know the following the question. You are agreed by this order in appeal, correct? By the commissioner. Aren't you agreed by that order, sir? Annexure 6.
Yes.
Against that order in Annexure 6, why can you not go to the stat? That's the question.
Because the para 9, the commissioner that appeal that directed remedy available under section that under Article 226 of the Constitution of India. Para 9.
He is not saying that the your lordship has Section 14 has interpreted and passed the order. Therefore, he says that it's without going to the sestat, he approach your lordship.
No, it only says the appellant may pursue remedy available either by way of a suit or by way of a writ petition. That is some gratuitous advice you have got. That's not the last word.
Lordship may be requested that let's have a copy. Tomorrow, Lordship disposal, I'll take instruction and
You come to page 69. Para E.
Counsel for the petitioner needs some time to examine whether the impugned order dated 29 January 2021 passed by the Commissioner Appeals Bhubaneswar can be challenged before the sestat, Kolkata bench. At his request list on Fourth April.
You have for me took some time.
Yes.
the copy may be searched so that I can take it.
All right.
My appearance may be noted in this.
All right.
Item 47.
May I please, my lord? My lord, I pray for a short date to file that amendment cost title, my lord. On the last occasion, my lordship was directed, but due to some unavoidable circumstances, it was not filed, my lord.
All right. At the request of Mr. Mishra, let's go. 9th August.
To 48.
May I please, your lordship? Before going into the fact of the case, my lord, I would like to draw a lordship's attention on Rule 52A of the Orissa Excise Rule 2017 clearly stipulates, may I read, my lord, a licensee shall sell an intoxicant only at the place or the premises specified in that behalf on the license. Then Lordship kindly come to the Annexure 1 series, page 8. The copy of the license I have appended. The condition number 8, Roman 8, clearly says that all spirit or liquor sold under the license be consumed on the premises. So premises, my lord, the plot number, khata number over there, I have constructed a 2-story building and a running IMF on-shop restaurant since 2018 and 19, my lord. What happened, Lordship will find, all of a sudden there was an inspection made by the Inspector of Excise who imposed, that is Annexure 2, on 2 grounds. First ground, operating more than 1 bar counter in the shop premises. Because I am very, so what is 15,000 for all? No, I have honored that, I have deposited. Well, what happened? In the premises, beyond premises, I have never made functional of my shop, on shop, my lord. Repeatedly they are coming and Lordship knows. So I have to that effect, after depositing the penalty of 15,000, I have made a representation to the collector to clarify what is the premises. Because I am doing my business within the premises. In that inspection report says in the premises.
There's no
Annexure
remedy.
5. There's no other remedy for him.
No, demand he has already paid.
No, only, but he's still questioning it.
He is questioning. Your Lordship may kindly see there are 2 prayers. First prayer is quas Annexure 3, demand notice. That has become infructuous because he is
infructuous. But second prayer is only clarification.
That the collector may be directed to clarify the meaning of premises. It is very much there in the act itself.
Because every month
that is why cost has been imposed, penalty has been imposed, and you have paid it. What is the question of clarification?
I have never violated the conditions of the license. Who will adjudicate the dispute? The collector, Annexure 5 is, I have given, my lord. Annexure 5. That is page 17. Can the collector examine it?
May I submit one thing? Law has been framed by the legislatures, and this act has been enacted. There is a rule, there is act, and now the collector will be called upon to give a clarification. This is, according to me, it is not proper, because collector is a very small, small officer to explain the act. Then your Lordship may direct that he should approach the government. Government will give the clarification. How the collector will give a clarification? Collector is a very low rank officer.
Because district excise officer is the collector, my lord.
No, maybe, but you need clarification of law.
Every month.
Law has been.
No, more only question, my lord, what is the premises?
No,
because
that
the rule says
what he asks is whether within the same premise, 2-3 counters can be opened or not.
Yes, that is the question.
That is violative of the license condition.
No, there is no such conditions, no such stipulated in the act also.
Your Lordship may direct the collector.
Collector, let examine.
Okay.
All the limited grievance, my lord, I have.
All right. A long period may be given. Because now we have, the collectors are busy in renewal of the license. So far as these matters are very.
Your license is valid till when? Till 31st March 2023. There's the point in coming for all this, sir. We leave the question open. We'll say that merely because since 1st November I have approached. Because immediately, so this will not constitute a precedent, we'll say.
Yes,
Yes, will not. All right. You see, the challenge is the present petition is to an order dated 31st October 2022, passed by the Superintendent of Excise Bhubaneswar, imposing a penalty of ₹15,000 on the petitioner under sections 64 and 75 of the Orissa Excise Act 2008, read with Rule 58 of the Orissa Excise Rules 2017 (OE rules). Paragraph. Counsel for the petitioner at the outset informs the court that the fine amount of ₹15,000 imposed on the petitioner by way of the impugn order has already been paid by the petitioner under protest. Full stop. The petitioner maintains that there was no justification for passing the impugned orders, since there was no violation of the conditions of the license for the petitioner's on-shop license. Paragraph. Considering that the license period itself is coming to an end on 31st March 2023, the court is not inclined at this stage to interfere. Full stop. Nevertheless, it is clarified that any further application for grant of on-shop license by the petitioner will be independent of and uninfluenced by the impugned order.
That's
The petition is disposed of.
Item 49.
Infructuous, my lord.
It is infructuous.
Dismissed as infructuous. All right.
Item number 50.
Item 50, 51 and 53. All are matters relating to that Sarath Parida. With your lordship's permission, may I give the other list of other matters of 2021-22?
Yes, yes.
Because last occasion 2020 matters I had given because the matter this bench was assigned with the 2020 matters.
52 also Sarath Parida.
All this 50, 51, 52, all similar.
50, 51, 52, 53. So far 52 is concerned, my lord.
Okay, same order. All right, same order.
In 52, I am
May,
appearing.
they come on 5th May.
In 52, I am appearing. The rest of the matters.
All right. Same, 5th May, is it? 8th May. All right. Taken on board, no? 8th May, taken on board in 8th May. Same order.
May I make a small prayer in these matters which I am submitting the list? My lord, my filing of requisite may be 1 week. Your lordship is usually giving 3 days filing of requisite. Since there are a bunch of matters, your lordship may get 1 week.
So you all have clerks, sir, your whole establishment. For you, it's no problem. Now electronic court fees, everything is easy. Very easy. All right. 50 appeals. 52. It will be very heavy for our stenos to take up the entire thing on board. So we'll spread it across. Today we'll take 10 of the matters, the rest will come up.
Today 10?
Every time, there's some matter will come up every day.
Yes.
I'm sure. So whenever that comes, the next 10 matters, you will take up with that.
That is right. But as your lordships wanted to furnish the list for the convenient to making a particular
So
date.
we'll keep this list with us. The court master will have it.
My lord.
Every time that matter comes up, another 10 matters will take it on board that day.
My lord.
10 matters will.
Item 53, I have got the respondent, ma'am. I am appealing for the respondent.
This is all first day disposal.
Has that disposal.
If you're agreeable, we send it back. If you're agreeable, we send it back. You're agreeable. All right. In 53, you say she appears for the respondent. Since the order was passed on the very first day without any opportunity to the appellant to file a reply, it is set aside and writ petition civil 25653 of 2020 is restored to the file of. It is 25653, no, sir? Yeah, it's restored to the file of the single judge in the roster bench, where it will be listed on 8th May. The appellant will file its paragraphs reply to the writ petition on or before 24th April, and rejoinder will be filed on or before 8th May. No further time will be granted for that purpose. The learned single judge is requested to dispose of the writ petition on merits as expeditiously as possible. The writ appeal is disposed. So the remaining will come up whenever. 8th May, is it? No. 8th May.
Item number 54.
I'm for the respondent, my lord.
None appears for the appellant. Dismissed for non-prosecution.
Item number 55.
May I please, my lord, in this appeal, petitioner challenged the order dated 11/12/2021 passed by the Honorable Single Judge, Ronnie page 9, my lord, the ordering persons. Simply, the learned civil judge rejected my restoration petition on the ground of limitation only, my lord.
What was the delay, sir?
My lord.
Extent of delay. How many days?
My lord, case, my lord. Petitioner filed one
Mr. Sadagi,
my lord.
what is the extent of delay?
Delay, my lord, the original case was dismissed by default. The concerned advocate was died. not informed.
How many days delay?
Days, my lord. 2010 hela, 2021 hela. More than about
1280.
3 years, 3 years, my lord. About 3 years.
Having heard learned counsel for the appellant and having perused the application for continuation of delay filed before the learned single judge, the court is satisfied that the court is concurs with the learned single judge that the extraordinary delay of over 3 years in filing the restoration application has not been properly explained and does not deserve to be condoned. The appeal is accordingly dismissed.
Item number 56.
My lord, the petition be liberty to place application for, my lord, not a restoration, my lord. The original case, my lord, regularization of a job, my lord.
We don't know that, sir. Yes.
56 within 2 weeks, Lordship, I'll cure the defects.
No delay pointed out. What is the matter about?
Lordship, is regarding dispute regarding residence certificate, Lordship. Now, Lordship, kindly come to page 123, Lordship. Now, page 123. Now, authority has issued a residence certificate. Now, authority has issued, audible, my lord? Audible, my lord?
Yes, yes.
Now, authority has issued a residence certificate. Since for 50 years, his family has been residing there. Therefore, this dispute could have been taken into account, Lordships. The dispute regarding 2013 to 2009, there is a residence certificate. He was belong to that village. 2013, they say he was not belong to that village. Thereafter, this 2021, this residence certificate issued by inquiring everything. It was filed before the civil judge, and the state came with filing the petition that admittedly this letter, which is as page 123, is belong to us, and there is no dispute regarding his residency over the area. Therefore, Lordship, I pray, Lordship, kindly give me some time to cure the defect. I have got a very big case.
And I am appearing for the corporation, my lord. In this case, my lord, he produced a certificate, my lord, saying that he belongs to a village, my lord, where the advertised location is situated, my lord. But that was challenged by a co-competitor, my lord. And ultimately, matter went to the Honorable Supreme Court. Honorable Supreme Court has said that the certificate which was issued in his favor, my lord, showing that he is a man of Brahmavarada, that's false, my lord. So
No. I had the occasion to appear before the Honorable Supreme Court.
Your
It was dismissed. Lordship says, you take appropriate step. Then I filed suit, Lordship, suit. They were called for Tahsildar and sub-collector. Tahsildar issued residence certificate by making inquiry. Everything is done. Now this page has justified after asking for 20 people. This residence certificate is issued.
This is another residence certificate, sir. This is not what you produced to.
Exactly. What he produced in 2003.
Rectified. It's like rectification of defect. That's
Yes,
what you have done.
Exactly. That's what my friend wants to do, my lord.
The original residence certificate submitted to the corporation was found to be a fraudulent one.
Exactly.
That
can't be cured, sir. You can't say now, after all that has happened, I've now again properly applied and properly got.
That's what I am praying. Lordship, kindly give me hearing. Let me file all the documents after 2 weeks. Let it come after 2 weeks, Lordship.
We are hearing you right now, sir. We are waiving all that defect. We are hearing you right now.
Lordship, because since it was in the defect list, I was not ready with the matter. That's the whole problem. Let it come on Monday, Lordship. Let it come.
This is all novel ways of further adjournments.
Let it come on Monday.
Why should it? We are ready right now. Carry on with your arguments.
Lordship, because what my learned friend is saying, I have to bring judgment and everything. Let it come on Monday.
Judgment will not improve the facts.
Let it come on Monday.
It will not. So judgment will not improve the facts. Carry on with the matter.
Lordship, first question of law requires consideration. Lordship.
No question of law. First, let's come to facts.
Fact is, Lordship, there was an advertisement for Rajiv Gandhi Grama Vitarak distributors. And in that, Lordship, the authority says, clause 2, Lordship, that is at page 47, Lordship, which authority allowed me to operate and says, if you are not residing the appropriate area, presently staying away from the location, you don't kindly shift to the location. This is clause 3.4. This is the relaxation given by the authority at page 47, Lordships. Page 47, Lordship.
Yes.
Kindly come to the letter of intent, Lordship.
Yes.
Clause 3.4. Shift your residence to Brahmavarda if you are presently staying away from the location.
Yes.
In order to personally operate the RGLS as stated in para 3. Thereafter, Lordship, I continue for 2019. Then in 2019, they extended it for 2000 up to 2024, Lordship. Now, some people made allegation that he is not belong to the same village before the sub-collector. Sub-collector declare my residence certificate as illegal without making any inquiry. Lordship, that was challenged. When it went to the Honorable Supreme Court, Supreme Court was pleased to dismiss. I had the occasion to appeal, Lordship, the order sheet. Then we said, Lordship, we are filing appropriate petition. We filed suit. In suit was admitted. And in a suit, we made an application for proper inquiry and application for direction to the Tahsildar. Now, Tahsildar made inquiry. After making inquiry through Tahsildar and RI, in presence of opposite party, private opposite party, it was found my residence, plot number, my house, everything for last 50 years, my father was staying, I am been staying there. I have got only residence certificate, I have got only voter ID card, I have got only plot number, holding number. That is the how this matter, the Lord Tahsildar issued this certificate. What is falling to my Lord's mouth, Lordship, that you cannot remove the defect, Lordship, that I cannot remove the truth came, Lordship. Truth came by virtue of throughout there was no inquiry. Throughout that there was no inquiry by the state authority. After state authority making inquiry came into the conclusion, yes, he has got only residence and he has been his family and he has been staying there for 50 years. And that when that was asked, the state says, the state file replied, that is in the should reply that yes, we have issued this certificate and it was properly inquiry was made by asking people. There was no grievance against this certificate. So this fact, Lordship, I humbly said, Lordship, this fact was, even though it was argued in question of law, this fact did not found consideration by their Lordship. That's why this writ I pray before learning Honorable Single Judge, Lordship, the suit is pending for adjudication. it will become, if any order is passed, Lordship did not find any, consider that aspect. Lordship.
Anything else, sir? All right. The present appeal is directed against an order dated 24th April 2020 passed.
Only I pray, Lordship, for a proper adjudication in the suit in view of the inquiry and everything. That should not be an impediment for me to get justice, Lordship.
Of 2020. Stop.
Then my voter card will become invalid.
Yeah. It challenged termination letter dated 17th February 2020, whereby Hindustan Petroleum Corporation Limited bracket HPCL bracket respond 1 bracket terminated the dealership agreement, LPG distributorship agreement dated 28th October 2013, which had been renewed on 9th March 2019. Paragraph. Question, the dealership in question was located at Brahmabarada Kalan, coming under the Rasulpur block of district Jajpur. So the question that arose was whether the residence certificate originally submitted by the appellate to satisfy the eligibility criteria for award of the distributorship was validly issued. Full stop. The inquiry made by HPCL revealed that the appellant was originally a resident of village Chandapur and not Brahmabarada. Full stop. Correct. It appears that while the above inquiry was in progress, the appellant produced another residence certificate dated 30th January 2013, issued by the Tahsildar Rasulpur, certifying him to be a resident of Brahmabarada. This was then challenged by respondent number 6. Before the sub-collector, Jajpur, by filing this appeal number 20 of 2013. Full stop. The said appeal is allowed by an order dated 27 January 2015, challenging which the appellant filed in petition civil 2582 of 2015 in this court. Full stop. The said writ petition was dismissed on 11 September 2017. Full stop. As a result, it got the factual position that the appellant was originally a resident of Chandapur and not Brahmabarada. Got confirmed. Full stop. The order of the learned single judge was further affirmed by the division bench on 5th February 2018 by dismissing writ appeal number 340 of 2017. Full stop. This was then again challenged. This was then challenged before the Supreme Court of India in SLP Civil 13004 of 2019. Full stop. That SLP stood dismissed. Full stop. The net result of the first round of litigation is that the appellant, being found to be a resident of Chandapur and not Brahmabarada, attained finality. Full stop. This made him ineligible for the grant of the dealership in the first place. Full stop. The cancellation of the dealership was therefore merely consequential upon the above litigation. Full stop. It appears that now the petitioner has gone with a civil suit.
Bearing suit number 268 of 2019.
Yeah. 268 of 2009, which is stated to be pending in the court of the civil judge bracket senior division, Chandi Court. Full stop.
For declaration right title over the property.
He again wants a declaration from that court that he is a permanent resident of Brahmabarada. Full stop. Unfortunately for the appellant, the fact of the pendency of the above civil suit was not disclosed in the first place in Writ Petitions Bill 6639 of 2020, filed before the learned single judge, questioning the cancellation of his dealership by the termination letter dated 17th February 2020. Stop. This added to the this compounded the difficulty for the appellant. Full stop. The learned single judge has rightly taken an adverse view on the conduct of the appellant. Full stop. Paragraph. With the, as rightly observed by the learned single judge, with the first round of litigation going against the appellant, thereby confirming that he was not a resident of Brahmabarada, but of Chandapur. The question of the appellant being able to overcome that difficulty and somehow assail the letter dated 17 February 2020, terminating of HPCL, terminating the dealership agreement, had to necessarily fail. Paragraph. The court is unable to find any error having been committed by the learned single judge in dismissing the writ petition by the impugned order. The appellant's writ petition by the impugned order. The writ appeal is accordingly dismissed.
Item number 57.
Only I pray, Lordship, the civil suit, it should not be, because Lordship, only residence he has got. Because he will lose his voter list also.
All right. Wherever he is, then he can vote there, sir. Yes.
Lordship.
And my presence is kindly be noted for respondent number 1, my lord, SPC. Deeply obliged.
57.
My lord, the noting is there steps for limitation not taken, but IAG filed 3827 by 2022 steps taken, my lord. Only
What's the matter about, sir?
My lord, I was praying for inclusion of my service 8392 as per the permissible rule, my lord, rule 6 of the Odisha Added Education Institutions Retirement Rules 81. So my lord, thing is that I was filing the documents while supporting the rule, but the way, my lord, the way was dismissed. I was absent, my lord, because of my absence, I could not place these materials. So
what material? Shows what material you wanted to place.
My lord.
Show the evidence.
My lord, my lord, the rejoinder, annexure 12.
Evidence.
Evidence. In the rejoinder, it is filed. My lord, the documents I have received under the RTI. My lord, the headmaster has sent a letter to the district education officer saying that his past service rendered from 83 to 92. So on available records, it is found that it is not been calculated for the purpose of pension. So which is a permissible rule. Rule 6 says that, my lord, it is permissible because when I was...
So when did you file the writ petition?
My lord?
When did you file this application? When did you claim this relief? When did you retire?
My lord, retired.
You retired as a peon?
Retired as a peon, my lord.
When?
By 2014, my lord. 2014.
Till 2017. Which date in 2014, sir? 30th June 2014.
30th June 2014.
So on 30th June 2017, you start an application saying include the above.
No, my lord, it was being calculated. Initially, I was getting provisional pension. So at the time calculation of final pension, so they deducted the earlier part of service, 92, 83 to 90.
Come to the learned single judge's order.
So my lord, single judge saying that, my lord, I could not produce the documents because it was the documents were there. So because of my absence, it is seen that I could not place it. So I pray, my lord, now the director secondary justice opinion number 2 may be moved, my lord, because after my lord retirement, the district education officer has sent a proposal to the director. So on my application appended in the rejoinder. So they are to take the decision. The director secondary education may be directed because rule 6 says that it is permissible, my lord. May pray. So rule 6, my lord, it is permissible under rule 6. So
may I pray your lordship may kindly see paragraph 6 of the impugned order, my lord, wherein it has been stated that this post was approved with effect from.
So it is a approval for
my lord. He might have served in a recognized university.
Now I am claiming a service benefit, my lord, because now I am confining my prayer to the pensioner benefit,
my lord,
not service benefit.
My lord, I am also on that, my lord. If your lordship will see, my lord, internal page, paragraph 6, my lord, his post was approved with effect from 25/9/1992, my lord. So, my lord, prior to that he might have worked, but that was a non-existent post. Only
no, my lord, rule 6 that
rule 6 says, my lord.
My lord, no, you are not interpreting properly, my lord. Only towards for the purpose of pension. My rule 6 says that in computing the length of qualifying service of an employee retiring after 1st April 92, all previous services except those rendered prior to the attaining age of 18 years, whether temporary, officiating, or permanent, either in one or more than one recognized education institution, shall subject to the condition sub rule 2, 3, 4, and 5 be taken into account for the purpose of retirement benefits. So, my lord, it is permissible. So, my lord, my opposite parties have granted the similar benefit to the other employees because the documents were not placed, my lord, to qualify the past services. So that is why my lord, earlier my lord, the pension sanctioning authority, my lord, disbursing authority control accounts did not take into account. So after the documents, my lord, if it will be sent by the district education officer to the control accounts, my lord, disbursing authority, so they will recalculate. So, my lord, on my grievance, the district education officer has moved to the director because the documents are available with us. So it is justifies that his earlier part of service has not been taken into account. So after getting the approval from the director, it may be taken into account and a revised pension paper may be submitted. So at least I pray, my lord, I will approve the director.
Come to the impugned orders.
My lord.
Come to impugned order.
My lord.
Page 8.
Page 7.
Page 8.
Page 7, my lord.
Page 8.
So,
Retable page 8.
Yes, sorry. My lord, page 8. Right. Well, the para 4, the petitioner has pleaded in the writ petition that he has retired as a peon of Panchayat High School, Vetara under D of Bhadrak, to include the period of service from 12/10/83 to 14/9/92 age qualifying service for the purpose of all service and pension benefits as per the government instruction dated 8/7/81 And my lord, in view of Rule 6(1) of Odisha Aided Educational Institute Return Benefit Rules 81, accordingly revise the pay and pension within time stipulated. So I'm not claiming any pay, my lord, because after, so Rule 6, it is being confined to the Retirement Benefit Rules 81. So the pension shall be revised because I don't require any the service benefit or pay or something. Only the period shall be counted notionally, and the last paid run, what last paid run, my pension shall be fixed. So Rule 6, I pray only to exercise Rule 6.
My lord.
How
do you read it?
I will place in computing the length of qualifying service of an employee retiring on or after the first day of April 1982, all previous service except those rendered prior to his attaining the age of 18 years, whether temporary, officiating, or permanent, either in one or more than one recognized educational institution, shall subject to conditions specified in such as be taken into account for the purpose of retirement benefit. My lord, but my lord, he was the period which he was claiming that he was officiating under a non-existent post, my lord.
No, that doesn't say this here. Yes. All service, all previous service.
All previous service means service against a valid post, my lord. That is variable submission.
No, where does it say? Where does it say all that?
Because, my lord, he was working under a private management against a non-existent post. That post came into force with effect from approval. That is 92, my lord. That is my submission subject to your lordship's acceptance, my lord. That is my submission, my lord. And on that ground, my lord, the single judge has turned down his prayer.
Don't so quickly finish your argument, sir.
I'm so sorry, my lord.
You don't want to even dwell on it.
I'm so sorry, my lord. I'm so sorry.
I have said it. Now you do whatever you want. That seems to be...
No, my lord. No.
Just read it slowly and develop an argument.
My lord, I'm so sorry.
Are you in a hurry or something?
No, my lord.
When you get an opportunity to argue, to elaborate how to read, you're letting go the opportunity. You're saying, this is how I'm reading it. This is how the single judge has said it. Now you do what you want.
Was not that, my lord. My lord, I am just placing...
Spend some time, sir.
My lord.
You're a lawyer. You're supposed to assist the bench.
My lord, I'm so sorry, my lord. Here, my lord, it has been written, all previous service, except those rendered prior to his attaining the age of 18 years.
Now, that exception doesn't apply. He's not asking for service rendered prior to 18 years. Now, which are the kind of services which is included?
My lord, whether temporary, officiating, or permanent, either in one or more than one recognized educational institution.
Now, this is a recognized educational institution or it is not?
My lord, in fact, my lord, the read file is not with me, but as appears from this...
see, once you start asking these questions, you're slowing down now.
My lord. My lord, because only...
You have to read it carefully, sir. Don't be in a hurry. If you want time, you say, let me examine it, think it over. When the court is putting a question to you, if you don't have an immediate answer, say, sir, I need to think it over. Then we can understand. Don't be in a hurry to get his writ appeal dismissed.
No, my lord, not in that way, my lord. I am so sorry, my lord, because my lord...
And then there is one more, subject to condition. So if he does not fulfill any of this subsection, subclause 2, 3, 4, 5, then again he doesn't get the benefit.
My lord.
So the exclusion clauses, if he does not fall within the exclusion clauses, he stands included.
Included.
That is his argument.
Yes, my lord.
He says, tell me, I'm not talking of service attained service before my attaining 18 years. Am I coming under any of this 2, 3, 4, 5? He's not. So why shouldn't my 9-year service be included? This is the question he's asking. You think it over.
My lord.
All right. You just say notice, he accepts notice. Counsel for the appellant has drawn attention to Rule 6(1) of the Odisha Aided Educational Institutions Employees Retirement Benefit Rules 1981 to urge that the period of service rendered by him between 12/10/1983 to 14/9/1992, that is prior to the official recognition granted to his appointment by the government, should be included for the purposes of computing his retirement benefits. All right. Notice that SIPS notice list of $14. You can say it's $16.
I'm so sorry, my lord.
No, it's all right. It's all a matter of learning, sir. Yes.
Item number 58.
58 and 59, my lord. I'm appealing for the individual respondents. They have already complied the order of the Honorable Single Judge. That is my instruction.
58? No, ma'am.
58 and 59.
Not order not complied.
I do not know. That is the letter I have received.
No. Order not complied.
You want to
8
check
to 2023. Dated is 8 to 2000. I'm reading out the order. My lord.
Yes.
1 minute.
Yes.
This is letter dated 25/1/2023, directed by the government to comply the order of the of this honorable court, which was complied on. Next slide. Which was complied by the director on my lord 3/2/2023 now.
No, my instruction not complied. Your lordship may fix it to Monday.
Mr.
My lord.
KP Mishra, learned senior counsel. Yeah, Mr. KP Mishra, senior counsel, refers to certain letters issued by the government of Odisha on 3rd February 2023.
Because yesterday they have contacted.
In compliance with the impugned order dated 9th March 2022 of the learned single judge in writ petition civil (OAC number 2981 of 2018.
Correct.
Mr. Kuntia, learned AGS, states time for instructions. Both these matters.
Yes,
58, 59.
58, 50.
And his request list on.
I will also supply the copies.
Yes.
20th March.
Ma'am.
Item number 60.
Please, the writ petition has been dismissed, allowed my lords without giving us an opportunity to file the counter affidavit. My lords, I'm giving similar orders, sir. The impugned order is at page 70.
No. Here the service is not complete, na?
Yes, my lords, here, my lords, it was.
No, there are other orders, sir, where we've issued notice and stayed. Where is that? This is not after service. No, this is the first time it's coming up.
No, yes, ma'am, this is first time.
Then this can't be the order, sir. This is where other side has appeared
Other side.
and we're sending it back. This is a notice. When are similar matters coming up?
Well, there are no similar matters here. I mean, because here the petitioner had asked for giving an opportunity to go for the training for being considered for promotion to ASI. The
1 minute,
matters
then let's see the impugned order.
Yes, ma'am. That's page 74.
Because your appearance is noted of the additional standing counsel.
Yes, ma'am. It's page para 5 on instruction. Mr. Panigrahi, learned counsel for the state, submitted that since the petitioner is facing a vigilance proceeding initiated in the year 2001, he is not eligible to undergo such training. Having heard such counsel for the parties, this court is of the view that pending of a vigilance proceeding that to initiated.
So what happened? This initiated in year 2001. Where are we on that?
My lords, it's ripe for trial. In fact, my lords, I have taken that ground also. My lords may see page 6 of my. Page 6, the first paragraph, my lords. This paragraph 2, which starts at page 5. The said Bhubaneswar Vigilance PS case number 38 of 2001 is posted to 1/12/2022 for trial. So the trial must have commenced by now.
21 years after.
No, 2002.
Yes, my lords.
It's posted for trial.
Yes, my lords. Posted for trial 1/12.
What happened on that date?
There's that, my lords, I have to take instruction.
Better find out.
Yes, my lords.
Police papers were supplied on 30th.
2012, charge framed on 2014. You see, notice, you see, it is now pointed out in the memorandum of appeal that there must be a suit number, I mean, the criminal case number. Why are you still referring to only the PS case number? And
Mas I'll provide the criminal case number, which is
that the criminal case against the respondent. In the criminal case against the respondent, charges were framed against him on 12th January 2014, and it is posted, and it is presently at the stage of trial. You say notice, then you say till the next date of hearing. What was the date of the impugned order?
As the date was 29/9/2022, there's a delay of 30 days.
No.
Yes, ma'am.
Look at the direction. Such an exercise shall be completed within a period of 3 weeks.
3 weeks from the day.
We are now far beyond 3 weeks. So
Yes,
this
ma'am.
is for going for training.
There's a contempt that is pending. Contempt number 7104 of 2022.
No, but once it was training, the next stage is naturally they'll have to do the once it not state of hearing. There shall be stay of contempt proceeding. The contempt case
7104
contempt case number
7104 of 2022.
7104 of 2022. List on 31st August. 31st August.
Grateful.
Item number 61.
Notice on and delay.
Right. Item number 61.
Your Lordship, as per report of the stamp reporter, SR could not be made due to non-filing of a VNAMA by the counsel for the appellant with the CMP 540. I am permitted to remove the defects.
All right, last opportunity to remove defects before the next date. List on 22nd March.
Item number 62.
Impugn order is at page 55, my lord. On the very first, the matter has been disposed of. That's my turn, page 55, annexure 2, my.
So there's no COVID now. This is.
I am for the opposite party.
So can you go back, sir?
My lord, in this case, the order was passed by the London court, my lord. In terms of the order passed in the honorable court, and as well as the referred the order of the honorable court being confirmed by the honorable Supreme Court, my lord.
Which one? Jagese Nisahu?
Yes, that our case is not covered by that judgment, and that rule said, my lord, what has happened in this case, ma'am?
Besides this is also barred by limitation, my lord.
But that is true, sir.
Yes, my lord.
But the question is that in para 3 simply says it is agreed by counsel of the parties, and name of the state council is also not indicated.
My lord.
And he's trying to distinguish
my lord, at the
your
presence
case from Jagese Nisahu.
My lord, at the presence of the state council, this order was passed, my lord. My sole prayer in this writ petition is that the petitioner to be covered under the OCS pension rule, pre-amended OCS pension rule 1992.
So they should file a reply to say whether it's covered or not, sir. These are all factual aspects, whether you're covered or not.
Yes, my lord.
It's covered, my lord.
You say no, he accepts notice. It is seen that the impugn order was passed on the very first day of the hearing of the writ petition. Stop. Although it is stated that open petition, it is agreed by learned counsel of the parties that the issue involved in this case is analogous to the one involved in WPC bracket OA number 901 of 2017 bracket Jagese Nisahu was state of Orissa bracket. Counsel for the appellant points out that the case of the respondent had to be examined by the appellant and an affidavit filed to show whether or not it was so covered. Stop. That opportunity was not available to the appellant since the writ petition was disposed of in the very first state. Stop. The name of the counsel for the state who is said to have agreed to the order is not indicated in the impugned order paragraph. Since this is a matter involving the question whether the petitioner is in fact covered by the old pension rules, it was necessary for the state to have filed an affidavit indicating the factual position. Stop. For the aforementioned reason, the impugned order is set aside. Right in between, you say delay control. And writ petition civil 5183 of 2022 is restored to the file of the learned single judge in the roster bench, where it will be listed on 8th May 2023. The state will file its para-wise reply to the writ petition on or before 24th April 2023, and the writ petitioner will file his rejoinder before 8th May 2023. No further time will be granted for this purpose. The learned single judge is requested to proceed with the writ petition and dispose it off as its conditions.
63 and 64 same.
No, are you appearing?
Yes, my lord. Besides this, my lord, kindly, besides this, my lord, the rule 2015, in rule 2000, amended rule 2015, rule is 2012 junior engineers rules, my lord. In this rule, categorically stated, in 2015 rule, my lord, the contractual period to be counted so far as promotion is concerned, my lord. If contractual period is so far as promotion is concerned, is counted, why not the OCS pension rule is covered in favor of me? That period, man.
Let them examine. Let them say what they have to say. So
yes, ma'am.
We're making it time bound anyway. So
time. Yes, ma'am.
62, 63, and 64.
Correct.
Item number 65.
May I please, my lords? My lords, this appeal has been prepared admittedly with a delay of about 100 days, 102 or 103 days. My lord, the short question that was before the Honorable Single Judge was as to whether the personal life, the misconduct of the personal life of an employee can be the basis for initiation of a disciplinary proceeding. That was the case. The Honorable Single Judge has decided that it cannot, because taking note of the duties and responsibilities embodied in Section 10 of CISF Act, the Honorable Single Judge has said it cannot constitute a case of disciplinary proceeding. Our only point is, my lord, your lordship will find section Rule 3 of Conduct Rules, which I have quoted at page 4 of my petition. 3 words only are staring at us. If your lordship comes to page 4 of the writ petition, writ appeal, I have quoted the Rule 3 of Conduct Rules. May I please, my lord? There it says, every government servant shall at all times, these 3 words, at all times. Thereafter, your lordship may come to Roman 3, do nothing which is unbecoming of a government servant, and Roman 6, maintain high ethical standards and honesty. These are the 2 at all times.
What happened in that criminal case?
No criminal case.
No criminal case.
Only allegation is that he was in love with a girl. He did not marry. She made a complaint to the authorities. Disciplinary proceeding was initiated. And
No criminal case, nothing.
No criminal.
What is all this?
These are not disputed.
Okay. You see, the challenge in the present, we're not inclined, sir. The challenge in the present appeal by the Union of India is to a judgment dated 1st August 2022, passed by the learned single judge, allowing writ petition civil 13495 of 2019, filed by the respondent. Full stop. Paragraph. The respondent joined the CISF as constable on 8 March 2010. Full stop. He was posted at the CIS unit, Mumbai Port Trust, and later deputed to work at a company in Jamnagar. Full stop. On the allegation that he was in a relationship with the woman, which continued for 6 years, and he breached the assurance given to her of marriage. Disciplinary inquiry was started on the complaint of the woman. Full stop. The inquiry officer returned the finding that the charge was proved. Full stop. The learned single judge, on examining the proceedings of the inquiry and the statements recorded therein, agreed with counsel for the respondent that even if the allegations were accepted, they related to the personal life of the respondent, and there was nothing on record to show that it had affected his discharge of duties as a disciplined personnel of the CISF. Paragraph. Having heard learned counsel for the parties, the court is unable to find any error having been committed by the learned single judge, coming to the above conclusion. Paragraph. Counsel for the appellant drew attention of the court to Rule 3 of the CCS Conduct Rules, which reads as under, reproduce it from page 4 and 5. Wow, it goes on and on, sir. No, just don't reproduce it. Rule 3 of the CCS Conduct Rules, and in particular, Rule 3 bracket 1, bracket 3. bracket, conduct unbecoming of a government servant, and 3 bracket 1 bracket 6 bracket, the requirement to maintain high ethical standards and honesty, unquote, bracket, and pose the question whether the subject matter of the disciplinary inquiry would attract the above provisions. Paragraph. The court is of the view that the burden is on the appellant, rather the authority, to show that such a conduct violated the above requirement. Full stop. Ultimately, as pointed out by the learned single judge, since the conduct is in the private domain, it will have to be shown that this has affected the discharge of duties by the appellant, by the respondent, Full stop. In the facts and circumstances of the present case, the court is unable to find, disagree with the conclusion reached by the learned single judge that the conduct of the conduct of the respondent was not such as to attract the above provisions. Full stop. Paragraph. No grounds have been made out for interference with the impugn order of the learned single judge. The appeal is dismissed. Delay is condoned. Contempt case, I think we can. Sorry, that's called 66.
Item 66.
May I please? Let's turn to page 31 is the impugn order. Order passed in a contempt proceeding beyond the scope of the original order passed in that original application. Page 31, my lord. It starts from page 34. May I draw my lord's notice to Annexure 1 order passed by the State Administrative Tribunal. Page 14, my lord. Page 15, last portion. Considering the aforesaid facts and on hearing learned counsel for the applicants and learned standing counsel, the way disposed up with a direction to the respondent to consider the claim of applicants for their observation under the control of CDMO Balangir. Then turn to Annexure 2. Annexure 2 is the resolution basing on which he is claiming for regulation. This resolution speaks the regulation of pharmacies, and that he is a attendant and appointed engaged in a schematic post, and that is a scheme also. So we rejected his case. Your lordship may see, in compliance to the order of the tribunal, we rejected his case at page 18 on 5/10/5/11/2030. Our rejection was that we have relied on notification that at 17/9/2013, your lordship may find it page 18. That clause 4, the resolution issued by the government of Odisha is not applicable in case of the applicant that they are not coming within the purview of the said stipulates the services of the contractual employee will if such employee fulfilling the following. In view of the last month, the prayer of the applicant deserves no concern. Accordingly, the same is rejected being devoid of merit. And we filed this complaints affidavit before the tribunal. This was rejected on the ground. Our complaints affidavit, page 22. In this case, your lordship may see the claim learned standing as subject for the order dated so and so to the complaints report filed by the respondent on 24/4/2000. The claim of the applicant has been rejected, quoting government of Odisha resolution dated 17/9/2013. In this case, the order of the tribunal is dated 17/5/2012 in way number so and so. And the rejecting the claim of based on a resolution of the government of 1 year beyond the date of order is not accepted, and accordingly the same is rejected. Thereafter, we filed a fresh complaints affidavit. See page 24. Annexing the order, page 29. Let's me see page 29, the last portion I am reading. And where the Honorable Court by the order dated 29/2021 issued notice to the opposite party number 2 file complaints affidavit by next day, that is 10/11. Accordingly, the order of 5 issued by
7 years. You filed this after 7 years.
But that was thereafter no in that contempt petition that was not taken up, my lord. Your lordship, when directed to file the complaints affidavit.
My God. So only when it came transferred to this court, you filed the affidavit.
And accordingly, that was rejected, madam. Once that is rejected, it is open for him to challenge the same. But in the contempt proceeding, the Honorable Single Judge had directed to regularize him or failing with him to appear in person on 27/3. 27/2, madam, that personal appearance. And when the tribunal had directed to consider his case, and we consider his case, and we found that it is not coming up for the regulation in terms of that.
What do you say?
My lord, we placed the order of the tribunal, your lordship, my learned brother has not placed the text, my lord, your lordship may see the order of the learned tribunal dated 17/5/2012. Just last para it was placed, your lordship, prior to 3 paragraph, your lordship may see.
Yes.
The government, my lord, the para starts. The government instruction at Annex 2 reveals that the government has decided for filling up the paramedical post, including pharmacists. Since the applicants also hold paramedical post, there is no reason why the Annex 2 should not be applicable to them. Admittedly, the applicants have completed more than 6 years of service, and therefore, in my opinion, they are eligible for absorption in accordance with the government instruction at Annex 2. It is also contended by the learned counsel for the order that the contractual MHU attendants in the district of Malkanagiri have been regularized by the CDMO Malkanagiri. Thereafter, considering the aforesaid facts, that was the order was passed, my lord. This was passed in the year 2012, my lord. And they have...
No, 1 minute. Just considering the aforesaid facts, just read that.
Considering the aforesaid, on hearing learned counsel for the applicant and learned standing counsel, the OA is disposed of with a direction to the respondents to consider the claim of the applicants for their absorption against the regular under the control of CDMO.
So against regular vacancies.
My lord.
The point is, if it's a scheme, it's not a regular vacancy.
No, my lord. They have to be regularized against the regular vacancies for which the CDMO, who is the appointing authority, has sought clarification that in compliance to the order of the tribunal, 56 posts are lying vacant under the regular establishment. We may be given permission for filling it in order to comply. The CDMO has the next order, your lords may see. The CDMO sought information from the government. And this is they are continuing since 28 years, since 95, my lord, as an attendant. And they have to be regularized against the regular vacancies. In one mobile health unit, my lord, there is a pharmacist, there is a A&M, there is an attendant, that is they are continuing, my lord.
They're still continuing.
Still continuing, my lord. Still continuing, and they are continuing since last 28 years. The posts are lying vacant. The appointing authority is the CDMO. When the direction was issued to the CDMO, and the CDMO wrote letter time and again that 58 posts are lying vacant under the class 4 establishment, you give permission. Those are the letters I have enclosed, my lord. In spite of that, the government set over the same and rejected. That was the tribunal rejected in 2014. So you can't reject when the government, the CDMO has wrote letter to give permission. That was rejected by their rejection. After that, my lord, when the contempt notice was issued by the learned single judge, my lord, in 2021, that means after 10 years of the order of the tribunal, now again they are rejecting by the same judge that it is not, your claim cannot be considered. And we are continuing since 95, my lord, and against our batchmates, those who are continuing in the same mobile health unit as a pharmacist, A&M, for them, the government has already taken decision and they have already been regularized. So far as the attendants are concerned, my
Why
lord,
is this discrimination? Other scheme.
that is the whole issue, my lord.
My lord, pharmacists continuing under mobile health unit.
No. Other attendants. Just come to this order at page 15.
My lord. It is also contained for the applicant that the contractual MHU attendance. I'm contractual. What is my lord? Some attendants, those who are initially appointed under that is MHUL mobile health unit, my lord. And subsequently they are brought about to the regular health care. They have been regularized.
What is the difference between them and this?
Here, my lord, they are, in fact, they are continuing under a scheme, my lord. That is
no. Even those MHU attendants were scheme attendants, right?
Yes, my lord. No. Initially, they were appointed under MH scheme. Subsequently, they are brought up to the regular scheme on contractual basis. Thereafter, they are regularized.
What's the difference, therefore? What did these people do that you have deprived them of this?
I understand, my lord. But admitted fact, they are continuing under a scheme, and now the government.
Can you keep somebody under a scheme for 28 years? What does it mean?
That is the central government sponsor. Your lordship, that is
central state government. How can you keep people under a scheme for 28 years?
Once that scheme
is complete exploitation. This is beyond Uma Devi and all. Total exploitation, sir. This is total exploitation.
And admittedly, your lordship. And
for people who served to you for 28 years, what is the least they can expect is this regularization? And so many vacancies, we are dealing with that other PIL. Vacancies after vacancies everywhere, not filling up.
In class 4.
You don't. Yes, huge, thousands of vacancies, sir. You want to know the figures? You're not aware. We are aware because we are dealing with the PIL. Thousands of vacancies. And you don't advertise, you don't fill up. Then there are people working for you 28 years. You don't regularize them. What is this? You don't neither want to recruit regularly nor regularize.
Then you'll also fix it to any date, my lord. I will take instruction whether that man can be accommodated.
Yes. This is one person, is it?
No, my lord. 10 persons.
Then all the better.
I'll take instruction.
So many vacancies, as your lordship rightly pointed. 66 vacancies that CDMO stated.
Just in this one district.
That they can be accommodated. I'll take instruction. That personal appearance is fixed to 27th, my lord.
Correct. Counsel for the appellate seeks time for instructions whether the 10 respondents can be regularized as attendants against the regular vacancies under the control of the CDMO Bolangir. At his request, list on 3rd April, sir.
Well, personal appearance is fixed to 27th, my lord.
We already stated that, no? Did we not state?
Personal appearance is fixed to 27th. No, my lord, they have come first time.
Achha. Oh.
Any contempt?
All right. The order passed. The further proceedings in contempt case number CP, contempt CP 248 of 2012 shall remain state. All right.
Well, let I read appeal maybe.
No, we're not. You should notice also.
Read appeal may be provided. Copy of the read appeal. Copy of the read appeal may be provided.
Yes, I'll
Item number 67.
My lord, they were to file an affidavit for dispersal of stipend.
Yes. There is a little confusion. My records shows that there is an affidavit which is filed by one deputy director of STSC counter affidavit. Sanghamitra Das, deputy director STSC, but the noting says there is no such affidavit is filed.
No, actually,
Lordship may kindly give me 1 week time to see if it is not filed. I will. But
No, the affidavit is the previous affidavit.
No. This affidavit is of dated. Yes, 11th January 2023.
Oh, that's not there. Mr. D.K. Mahathi states that he has with him an affidavit dated 11 January 2023 of the Deputy Director, ST and SC Development, Minority and Backward Classes Welfare Department. However, the said affidavit is not on record. He'll ensure that it's brought on record and an advance copy is furnished to the petitioner who appears in person. List on 11th April. Sir.
My lord, it may be earlier.
There's no date, sir. We are also trying hard. There's no date.
So, in March, my lord.
Difficult.
Item 68.
Your Lordship, item number 68, Your Lordship may kindly look into the cause list. AD noted back from opposite party number 3. However, we have already filed counter and also the petitioner has filed rejoinder, Your Lordship. Your Lordship may fix up with the permission, Your Lordship may fix up a date for final hearing of the matter, Your Lordship. But in the meantime, because that opposite party number 3, Your Lordship, notice has been issued, but AD not back.
Party number 3, my lord, is the seller at Delhi.
Taylor, Your Lordship.
He may not also come.
Fresh notice to opposite party number 3, returnable. On the next date, tracking report be placed on record. List on the all right. Interim order to continue. List on 6th July.
Item number 69.
You continue.
May I please, Your Lordship? Here, my lord, in this writ application, I am challenging rejection of my application for settlement under that Vibad Se Vishwas Act, my lord. My lord, may I kindly turn to page 32, Annexure 7. This is the order, my lord, where my application for waiver of penalty under 273A has been rejected, my lord. So, assailing this, I have filed a writ application.
What do they say in the reply?
My lord?
They filed a reply.
Yes, my lord, they have filed a reply. Very short question involved, my lord. Challenging this Annexure 7, I have filed a writ application, which is pending before this honorable court. In fact, it is now today. It is also tagged, my lord. During pendency of this writ application, this act came, my lord, which also I have annexed, page 34, Annexure 8 series. I have made an application under that scheme, and that application is at Annexure 9, page 56. My lord, may kindly turn to. Disclosing about pendency of this writ application and all. Thereafter, my lord, after considering and adjudicating on this application, Annexure 10, page 67, they have issued me the certificate. At page 68, they have said this is the amount to be deposited on or before 31st March, that is 2,89,000. Within 15 days of this order, you have to deposit so as to be governed by that act. Next page, page 69, I have made that deposit within the 15 days, my lord. Thereafter, my lord, page 70, Annexure 12, they have rejected it. After I having deposited, and that order has attained finality because section 5.1 says it's conclusive. Upon issuance of this certificate and the deposit, it's conclusive. In any way, my lord, Annexure 12, page 70, they have rejected it on the ground. I am placing that. Please refer to your application under DTS SB. In this connection, it is to inform you that your case is not eligible for DTVSB as the writ filed by you is against the rejection of penalty waiver petition. As per circular number so-and-so dated 4/3/2020, waiver petitions are not appealed within the meaning of DTVSB. I will come to that. This reasoning is also how, my lord, this reasoning is not proper. Prior to that, my lord, may kindly turn to page 39. This is the act, Vibad Se Vishwas Act. I'm just placing an section 5, my lord. Section 5.1. The designated authority shall, within a period of 15 days from the date of receipt of the declaration by order, determine the amount payable by the declarant in accordance with the provisions of this act and grant a certificate. My lord, this certificate has been granted. Subsection 2, the declarant shall pay the amount within 15 days. I have paid. Subsection 3, every order passed under subsection 1 determining the amount payable under this act shall be conclusive. Now, a conclusive one there without any allegation of fraud or misrepresentation, my lord, they are now rejecting that. Now, my lord, kindly turn to the circular they are referring to for rejection, my lord. That circular I have annexed, my lord. Annexer 13, page 71. That circular. In fact, that circular, it's a clarification. And page 75, they are referring to this question number 13, page 75. With respect to interest under section 234A, B, C, there is no appeal where the RCC has filed waiver application before the competent authority which is pending as on 31st January 2020. Will such cases be covered under the Vivad se Vishwas? No, such cases are not covered. Waiver applications are not appealed within the meaning of Vivad se Vishwas, my lord. Now, exactly on this point, my lord, the Honorable Delhi High Court has set aside this reasoning, my lord. I'm just relying upon one reason.
I think we'll continue after lunch.
May I please?
Please.
As I was highlighting, the first point that once they have issued me a certificate under 5.1 that attains conclusive, that is conclusive and it cannot be reopened. To that, my lord, in their counter, they say, page 2 of their counter, paragraph 2, in the instant case, although the petitioner filed an application dated so-and-so in form 1 and 2 for full and final settlement of tax areas in respect of assessment area so-and-so under section so-and-so, and wrongly a form 3, this form 3 is a certificate, was generated in system-wide acknowledgement number so-and-so dated so-and-so. The said form was not signed by the principal PCIT Bhubaneswar and also not issued to the assessee. So that is their stand, my lord. In this respect, my lord, kindly turn to the rules, page 42, Vivad se Vishwas rules, page 42 of the writ petition. Rule 4, my lord, at the bottom, the designated authority shall grant a certificate electronically. So I have been issued that certificate electronically, my lord. Now coming to the merits of the rejection, my lord, they say that waiver of penalty is not your application for waiver of penalty is not an appeal, so it's not covered. In that respect, they refer to page 75, the clarification. Question number 13. On this ground, they say, the question which I played, that it refers to 234A, B, C interest waiver. The answer is no, such cases are not covered. Waiver applications are not appealed within the meaning of Vivad se Vishwas. My lord, I was placing that judgment, my lord. I have not handed over. Paragraph 4, my lord. In this case, while the CIT accorded waiver of penalties on so-and-so under section so-and-so, as regards waiver of interest, the petitioner filed an application under 222A before the CIT for the year so-and-so and so-and-so in March. This application for waiver of interest was rejected by the CIT on so-and-so. The petitioner then filed an application bearing company application number so and so, disputing this rejection under 222A, on which this court issued notice. So in that case, it is the denial of waiver of interest that was challenged before the company application, because that company at that point of time was under liquidation. In this respect, my lord, kindly turn to paragraph 8 of that judgment. Next page. The respondent CIT filed a counter affidavit stating inter alia that the company application number so and so filed by the petitioner against the order of rejection of waiver application was primarily a petition under Companies Act and not an appeal within the meaning of the BSB Act. It was further pointed out that in the counter affidavit that the reasons for rejecting were available in the e-filing database and stated as under FAQ 13, which I have read out to your lordship. Now, my lord, kindly turn to paragraph 14 at page 5. May I please? Gravamen of the petitioner's case is that the declaration under Form 1 and 2 requesting for settlement of their tax arrears relating to disputed interest ought not to have been resolved under the VSB Act, since they fell within the scope of Section 3 read with Section 21H and 210. The CIT, however, was also relying on definitional sections to contend that while tax arrears included disputed interest, but the disputed interest was only in a case where an appeal has been filed and rejection of the waiver application prior in time by the department could not be considered an appeal and the petitioner would not be an appellant. Now, paragraph 15, by referring to the various definitions in the Vivad Se Vishwas Act, my lord, may I just place next page, page 6 at the top. It starts, in fact, from the last, the definition of dispute in rules. I'm just reading from page 5, last 2 lines. The definition of dispute in relation in rules does not deviate or is ultra vires the scope and intent of the VSB Act itself, since the preamble of the VSB Act itself provides for resolution of disputed tax and most importantly for matters connected therewith and incidental thereto. It is therefore obvious that the intent of the VSB Act was to provide resolution of all nature of disputes relating to tax, penalty, interest, fee as determined under the provisions of the VSB Act. The restrictive scope that the CIT is providing for definition of dispute or even of an appeal is not in synchronicity with the letter and spirit of the VSB Act that propounds an ameliorative scheme for resolution. So looking at the intent, the court said that it is all pervasive. Now coming to that FAQ 13, that is answered in paragraph 16. Reliance by CIT on FAQ 13 is not tenable since, as rightly argued by the learned counsel for the petitioner, FAQ 13 relates to a pending waiver application before the department and not a proceeding emanating out of a decision by the department on a waiver application, which company application number so and so was. This is also obvious since if the department itself is seized of a demand by the assessee and has not passed a decision on it, then there is no dispute. Here, my lord, assailing that rejection of waiver of penalty, I am before your honor in a writ application. During pendency of that writ application, I have made that application under the VSB Act. So it was not pending before the department as per that FAQ 13. And I have checked also, my lord, this decision has not been overruled, my lord. So I'm squarely covered by this decision as regards the merit of the rejection, and on that conclusiveness, they cannot review now without any allegation of fraud or suppression.
My lord, I have written the counterfeit at page 8 of the counterfeit. The averment made by the petitioner that the referred circular talks about waiver applications in respect of the interest and not penalty. Disputed penalty very well fall under the ambit of DTBC scheme pursuant to section 3 of DTCB Act is not true at all. The question number 3 referred to interest. However, in the answer, it has been clearly mentioned that no such cases are not covered. Waiver application are not appealed within the meaning of Vivad Se Vishwas scheme. It means that the waiver application in general are not covered under the DTCB Act. Waiver application are not like mercy petition, solely ground on the consideration of specified authority. The same are not challenged or disputed petition against the imposition, levy of interest and penalty. This is the question 3. And last in the judgment also, last time, therefore, the writ petition disposed of setting aside the rejection dated 5th January 2 and Form 1-2 filed the petitioner by the Principal Commissioner Income Tax with the direction to the CIT to re-examine.
No, now in In that case, it was rejected. In my case, they have given me the certificate, I have deposited and they have accepted that. So that.
All right. The challenge in the present petition is to an order dated, an order oblique letter dated.
Yes, annexure 12 is rejected.
20 January 2021. Issued by the Principal Commissioner of Income Tax, Bhubaneswar, bracket PCIT, informing the petitioner that the petitioner's application under the Direct Tax Vivad was Act, bracket DTVSV, was not eligible since it was filed open question against the rejection of penalty waiver petition, unquote. It was stated that such applications, such waiver petitions were not single quotes appeal, unquote, within the meaning of DTVSV paragraph. The background facts are that the petitioner is a Hindu undivided family, bracket HUF, which is an income tax assessee. Full stop. The petitioner filed a return for the assessment year, bracket AY 2014-15 on 19th March 2015, disclosing a total income of 12,95,840 and admitting tax liability at rupees 225,315. Full stop. Long-term capital gain on shares was disclosed as rupees 37,35,321, and yet the said income was claimed to be exempted under section 10 bracket 38 bracket of the Income Tax Act 1961 bracket IT Act paragraph. In the scrutiny assessment that followed, the assessing officer, bracket AO, passed an assessment order dated 29 July 2016, accepting the disclosure by the petitioner and determining total tax and interest at rupees 1840,073. Full stop. The entire tax demanded was deposited on 3rd and 9th August 2016. Paragraph. The AO, however, initiated penalty proceedings under section 271 bracket 1 bracket Roman small c of the IT Act and ultimately passed a penalty order dated in December 2016, raising a penalty demand of rupees 1159,091. Paragraph. The petitioner then filed a petition under section 273 capital A of the IT Act, seeking waiver of penalty. Full stop. A supplementary petition was also filed for the same relief. Paragraph. The PCIT Bhubaneswar intimated the petitioner by letter dated 30th May 2017 that approval for waiver of penalty was not accorded. Writ petition civil 13576 of 2017 was then filed in this court, questioning the levy of penalty and rejection of the petitioner's application for waiver. Paragraph. While the said writ petition was pending, the DT-VSV Act came into force on 17th March 2020. Stop. The petitioner made an application in Form 1 to the PCIT Bhubaneswar on 2nd December 2020 for full and final settlement of the arrears in respect of AY 2014-15. Paragraph. In terms of Section 5 of the DT-VSV Act, the PCIT Bhubaneswar determined the amount payable by the petitioner for such full and final settlement. The electronically generated certificate in Form 3, dated 14th December 2020, was furnished to the petitioner, and in terms thereof, the petitioner paid rupees 289,773 on 23rd December 2020. Full stop. Paragraph. On 20th January 2021, the impugned order was issued by the PCIT Bhubaneswar, informing the petitioner of the rejection of its waiver of its application under the DT-VSV on the ground that waiver petitions were not appeals within the meaning of the DT-VSV and in terms of Circular Number 7 of 2020. Dated 4th March 2020. Agreed. The petitioner has filed the present petition, in which notice was issued on 18th May 2022. We'll stop. It was indicated that the payments made by the petitioner pursuant to the DT-VSV would be subject to the outcome of the petition. Paragraph. In response to the notice issued in the petition, a counter-affidavit has been filed by the department, dated 15 June 2022. Full stop. Inter alia, it is contended that in terms of question number 13 of the Circular Number 7/2020, dated 4th March 2020, single quotes, waiver applications are not appealed within the meaning of Vivad Se Vishwas, unquote, and therefore the petitioner's request application under the DTVSV was rightly rejected. Stop. Reference is also made to section 273 capital A bracket 5, which states that every order made under that provision, open quotation, shall be final and shall not be called into question by any court or any other authority, unquote. Paragraph. This court has heard the submissions of Mr. S.S. Padil, learned counsel to the petitioner, and Mr. Chimanka, learned senior standing counsel to the department. Paragraph. Where does it say it is electronically issued? That
Rule 5, rule one next, page 42. Rule 4.
It is seen that under the DTVSV rules 2000, in terms of rule 4, open quotation, the designated authority shall grant a certificate electronically referred to in subsection 1 of section 5 in form 1. We'll stop.
Form 3.
Under rule 5, no, full stop. Further, even forms 1 and 2 and form 4 shall be furnished electronically under digital signature. Full stop. In other words, once a certificate in terms of rule 4 is generated, it should be taken to be conclusive. Is there a rule which says that?
5.3, page 39, section 5.3.
This is made clear under section 5 bracket 3 of the DTVSV Act. Which reads thus. Take from page 39. Paragraph. All right. Section 5, which reads as under. All right. Paragraph. When both section 5 of the DTVSV Act as well as rules 4 and 6 are read together, it is claimed that for operationalizing the DTVSV scheme, the department has decided to adopt the electronic mode. Full stop. In this mode, certificates generated electronically would have the same probative value as certificates issued manually. Stop. This explains why Section 5 itself accords imprimatur to an electronically generated certificate. Paragraph. The stand taken in the counter affidavit of the department is simply that
Page 2.
Yeah. The certificate had been wrongly generated, and that because it was not signed by the PCI and also not issued to the SSC, it should not be acted upon. Full stop. In other words, it's not disputed that such certificate is in fact generated, and the petitioner has also made payment pursuant to the generation of such certificate. Full stop. Paragraph. Therefore, the explanation offered that merely because the said certificate was not signed by the PCIT and not issued to the petitioner would not result in nullifying such certificate. Full stop. Paragraph. It also appears to the court that the stand of the department in its counter affidavit that waiver applications would not constitute single court's appeal, unquote, for the purposes of the DT-VSV scheme, is not also entirely correct. Full stop. The relevant portion of the circular number 7 of 2020 dated
March 2020, page 71.
4th March 2020, which is relied upon by the department in this regard, reads as under. So that, which page is that?
75, question number 13.
Page 75, question 13, both question and answer. As pointed out by Mr. Paddy, learned counsel for the petitioner, the question itself respects talks of applications for waiver of interest and not for waiver of penalty. Full stop. Secondly, as explained by the Delhi High Court in Capri International Private Limited versus Commissioner of Income Tax -4, 2022, 328 CTR 662, bracket Delhi, bracket. The waiver application referred to in the aforementioned question number 13 should mean, unquote, a pending waiver application before the department and not a proceeding emanating out of a decision by the department on a waiver application, unquote. Further, it was explained by the Delhi High Court in Capri International Private Limited, Supra, relying on the judgment of the High Court of Bombay in Sadruddin Tejani versus ITO, 2021, 434 ITR 474 bracket Bombay bracket, that the DT-VSV Act is a beneficial legislation for both the revenue and the taxpayer. And interpretation of its provisions, of the provisions of the DT-VSV Act, has to accordingly reflect the object and purpose of the statute. Full stop. It was explained in the Delhi High Court that, single quotes, any proceeding challenging a decision by the department in respect of tax, interest, penalty, fee, etc., would come within the purview of a dispute which would enable a party to approach the department for a resolution under the VSV Act, unquote. Mr. Party states that, to the best of his information, the above decision of the Delhi High Court in Capri International Private Limited, Supra, has not further been questioned by the department in appeal. Paragraph. The court is of the view that in the present case, the answer to FAQ number 13, forming part of circular number 7 of 2020 of the department, does not enable the department to reject the petitioner's application under the VSV, only because it was an application for waiver of penalty that had been filed by the petitioner. Paragraph. None of the reasons cited by put forth by the department to reject the petitioner's application are valid or convincing. Full stop. Paragraph. Mr. Chimanka then pointed out that the relief granted in Capri International Private Limited, Supra, was only for the matter to be sent back to the PCIT. No, to the CIT, sorry. No, to the PCIT, to in turn direct the CIT to re-examine or reassess the declaration filed by the petitioner and decide the application on merits. He accordingly submitted that in this case also a similar direction should be issued. Paragraph. As pointed out by Mr. Party, in the present case, the department had already accepted the application filed by the petitioner, and in proof of such acceptance, the system generated certificate under Rule 4 of the DTVSV rules was issued to the petitioner. Full stop. It had the stamp of finality and conclusivity in terms of Section 5(3) of the DTVSV Act. Full stop. In other words, the department cannot possibly resile from such certificate on the ground that it was not physically printed out or not physically signed by the PCIT. Full stop. It had the same effect as a certificate validly issued, which has then been acted upon by the petitioner. Full stop. Paragraph. Further, as I already explained, the department cannot deprive the petitioner of the benefit of the DTVSV only because the petitioner filed an application for waiver of penalty. Full stop. Following the judgment of the Delhi High Court in Capri International Private Limited, Supra, this court holds that such an application for waiver of penalty cannot be said to be ineligible for consideration as an single court's appeal, unquote, within the meaning of the DTVSV Act and scheme. Paragraph. For the aforementioned reasons, the impugned order letter dated 20th January 2021 of the PCIT Bhubaneswar is hereby set aside. Full stop. The result would be the petitioner's application under the DTVSV for the AY 2014-15 will be treated as accepted. Full stop.
Connected date application will become infructuous, my lord.
Paragraph. In view of the above order, in the separate order in the set connected, you say the writ petition 11275. Writ petition is disposed of in the above terms with no orders as to cause. The next writ petition, you say in view of the order passed today in 11275/2022, this writ petition has been rendered infructuous and is disposed of as such.
Item number 70.
72, 73, Your Lordship, that is in absence of second appellate tribunal, Your Lordship, GST tribunal.
Right.
Only in 71, Your Lordship, my learned friend has given me the reply.
Your Lordship, at 71, we have filed the reply yesterday. So that may be tagged with Your Lordship. And 72, 73, Your Lordship, 4 weeks more time may be granted.
What about 70?
70, 72, and 73.
All right.
70 minute, I am happy with you.
All right. Just put down all these matters and you say, while reply has been filed in writ petition civil 27443 of 2022, the replies in the other writ petitions will now be filed, as a last charge, within 8 weeks. Rejoinder to all the replies be filed for the next date. Interim order to continue. List on. September.
Item number 74.
Item
74.
74 is similar to yesterday's 72 item matter. Pollution matter. Today they have sought the counter. Not I will file rejoinder. Lordship, yesterday I said that pendency of the writ petition will not bar for renewal of license. That was the order last. Yesterday's 72 item. WPC 23248 of 2021.
All right. Just say counter has been filed by the opposite parties. Rejoinder be filed for the next date. And then you repeat.
The Lordship directed 18/7, posted to 18/7.
List on 18 July.
Yes, pardon, my lord. As per noting, second copy of the counter not served. Permitted to file the second copy for this court.
Item number 75.
Lordship, may kindly see order dated 12th of January. Lordship, already pleased to apply mind, and Mr. Mahanti was supposed to file counter in the matter.
He said counter be filed within 8 weeks, rejoined for the next date. Interim order to continue. 12th September.
Item 76.
13th.
My lord, may I submit to one thing? In this type of Bhadrak demand notice, item 75, in one case, your lordship has already directed them to file appeal before the.
No,
that's Mr.
a
Junior
different-
Ratha was appearing and he.
So there we have filed application to recall, saying, citing this, because here is a case, your lordship has been pleased to apply mine, 1516. 1516.
In that case also his notice was issued. Thereafter your lordship has, now he is saying that he has filed a recall petition. I don't know, but similar.
Only after discussing with Mr. Mahanti, I have filed recall application.
No, you are free to file the recall application. How can I stop you filing all these things? But according to my respectful submission, this order is what your lordship has passed. This is order which is applicable. That government order cannot stand on the way. Yesterday also your lordship has passed one order which.
Mr. Mahanti try to avoid file counter affidavit.
No, not. That should come in.
No, I'll argue it. Mr. Mahanti is ready, I'll argue it. I don't mind. But then sending me to
yesterday also similar matter. Your lordship has direct. Mr. Junior.
I listen, Lord. Let me then submit a line. 1516, my lord. For the first time, they introduced theory of interchangeability because they could not supply liquor. Interchangeability was allowed. Interchangeability, after allowing, they raised us a demand. We paid the demand. Thereafter, they issued me NOC. License was renewed from 1516 up to 2021 till the lottery was held for the first time. Now, thereafter, government is revising the MGQ for 1516 in 2021. That's the point. Government cannot do that. Retrospective effect, revising MGQ of 1516 is not permissible. And on that basis, this demand has been issued. That's the reason we are challenging that government order, and Mr. Mahanti wanted to file counter. Whether MGQ can be revised with retrospective effect 5 years after we have issued the no due certificate. That's the point. Okay.
All right. This same order will remain.
Yes.
Which date your lordship?
12th September. Item 76.
3 matters same.
Yeah.
75, 76, 77. Item number 78.
Interim order.
But 78, yesterday I received the counter. I want 2 weeks time to file rejoinder. I have received yesterday counter.
All right, rejoinder will file for the next date. Is there interim order?
Yes, my lord, interim order.
Interim order to continue list on.
All the matters same.
13th September.
Item number 79.
79, I pray this matter will taken some other day, my lord. Some difficulties, my lord. File has been.
So, my lord, they are very old matters. Review petition of 2010.
My lord. Here, my lord, the petitioner has filed this review petition, my lord, challenging the order of the Lord Singh. Wherein the petitioner's case is that he has participated in the selection process for appointment as a fireman, my lord. And in the selection process, although he has been found selected, and at the time of appointment, those persons who are more junior to the petitioner, they have been allowed to join, my lord. And in the same selection process, my lord, the notification has been made wherein more than 60% of the post have been reserved for the reserve category in violation of the statutory provisions of law. That has been challenged in the said writ application, my lord. While deciding the same, the Honorable Court has not taken care. I have also specifically mentioned, my lord. Now, my lord, my lord, although 30 seats has been kept for reservation for the selection process, 70% post has been made for the reserve category in violation of the.
All right. Now, no grounds made out for review. The review petitions are all dismissed. What is this 9894 of 2000?
Similar, batch of rate application.
98 is different, perhaps. 989 for 2003 is different.
Yes, that is on sales tax matter, Your Lordship.
Oh, 98.
Related meaning what? In what sense? All right. In view of the dismissal today of review petition number 15 of 2010, this petition is dismissed. All right.
Item number 80.
May I please, Your Lordship? In pursuance of Your Lordship's directions, on last occasion, I have filed my written notes of submissions. The matter have been remanded back by the Honorable Appeals Courts.
Correct. Last time, I think Mr. Mishra wanted time.
Your Lordship, no. Your Lordship, I have already filed written submission. Your Lordship, due to paucity of time, Your Lordship, that has been adjourned on the last occasion.
Okay.
Your Lordship, the matter have been remanded back to these Honorable Courts on the question of 3 points matters.
Right.
B, D, and E. So far as the D and E is concerned, matters both are common. The receipts of higher charges from the contractors by the petitioners matters. That do not constitute any shares under section 2G IV of the Orissa Sales Tax Act.
Correct.
I have explained details in my written notes of submission. Kindly have a glance to page 6. May I read?
Yes, please.
With regard to recovery of higher charges from contractor, the same do not constitute any share as contemplated under Section 2GIB of the Orissa Sales Tax Act. The use of petitioner's machinery by the contractors do not cause any transfer of ownership of machinery from petitioner to the contractor. Further, the control of the machinery remains in the hands of the petitioners. Further, higher charges realized from the contractor cannot be considered price for transfer of right to use machinery. Under Section 2GIB of the OST Act, the effective control of machinery is inside the plant and is with the petitioner. The contractor only uses the said machineries inside petitioner's plant premises and for petitioner's work only. The contractors in this regard are neither allowed to carry the machinery outside the petitioner's plant, nor the contractors could use the machineries other than petitioner's work. That I have explained in my tax revisions applications para 12D. There are 12F of the my tax revisions applications, madam. 12F, madam. I have explained it.
Yes.
And so far as the point number B is concerned, madam, that relates to the non Sestas Tribunal was pleased to reject the decisions of the taxing authority to tax 70% of canteen sales at the rate of 4% tax, the rest 30%.
So far as the canteen sale is not here.
So far as the point number B is concerned.
The point number B is the first point tax paid.
Yes. That relates to the London Sisters Tribunal was pleased to hold the same to be subject to tax at the rate of 4%. The entire canteen sales. That includes the tax free and also the first point tax paid items, the cigarettes and the breads, also the canteen sales, madam. That includes. That I have avoided in my tax revision applications, para 12B of my tax revision applications, madam. That is the sole contention of the petitioner.
Your Lordship, so far as the ground number B is concerned, so far as whether London tribunal is justified in not deleting the tax free and first point tax paid goods turnover from the taxable turnover, as such the order is illegal and this ground has not been taken anywhere, Your Lordship. Before the tribunal, this ground has not been taken. So, since this ground is not before the tribunal and it has not been decided, no evidences have been produced ever, Your Lordship, for any of the authority, Your Lordship. For that reason, he cannot take a new ground, Your Lordship. For that reason, I have narrated from page 3 to by Your Lordship, some of the judgments I have narrated, Your Lordship. And then new phrase, Your Lordship, in CIT versus India Stream Navigation Limited Air 1961, it clearly says that what will be a question of law, Your Lordship. So here, Your Lordship, it is even the expression any question of law, Your Lordship, arising out of such order, but that can be summed up as, Your Lordship, at page 5 I have narrated, Your Lordship, how that can be a question of law. Now, Your Lordship, since they have not produced any evidence before the tribunal, so it cannot be taken as a ground question of law. Now, Your Lordship, so far as the next two question of law, so far as that right to use, Your Lordship, higher charges, Your Lordship, at page 7, I have narrated that portion, Your Lordship, how the tribunal in a justification reason has passed the order. And also, on phrase, Your Lordship, I may be permitted to pass these honorable court's one judgment, Your Lordship, in case of Krishna Chandra Behra, how the higher charges is taxable with the extended opinion definition of sale, Your Lordship.
Control, possession, all of that.
Your Lordship. That in basic of Your Lordship. Your Lordship. Your Lordship, so far as the higher charges, Your Lordship. Same, Your Lordship, the right, Your Lordship, rights and privileges, Your Lordship, everything is same to that of the judgment, Your Lordship. And the and also the complete is Your Lordship, how the tribunal, Your Lordship, also at page 8, Your Lordship, page 8 of my submission, Your Lordship, may kindly turn to page 11. Your Lordship, how the tribunal has considered the issue. That is, I have quoted from page. Your Lordship,
there are 3 copies. Sure.
Page 11 of my submission, Your Lordship, that I have taken from the order of the tribunal in the first brief at page 81. The next dispute resolves around the taxability of higher charges received by the appellant from different contractors who are hiring out of its machineries like crane, dozer, pumps, air compressor, jackhammer, road roller, tractor to different contractors for utilization in the modernization work. It is submitted by the learned advocate for the appellant that to establish sale 2G4 of the OST Act revenue should be established the transfer of right to use. In the case of the appellant, no transfer took place. Machineries are to be either indented through a certificate of requirement from the concerned engineer, and on such certificate, the concerned department engaged its own operator to run the machine. Cost of operation for each machine is fixed earlier on hourly basis, even when the department of the appellant uses the machine of the other department. The user department is charged for such use of ship hourly basis, we plead that the ownership and control over the machinery during the period by use by the hirer remained always with the appellant, and therefore the receipt by the appellant never come within the ambit of deemed sale as envisaged under section 2G4 of the OST Act. In support of the argument, the learned advocate cited the following judgment, so and so, so and so, so and so. The learned SR of the revenue defended the finding of the learned SCST contending that the term or ratio laid down by Honorable High Court in the case of KC Behra versus State of Odisha, SC STC 325, and by the Honorable Bombay High Court in case of 20th Century Finance Corporation, State of Maharashtra, 72 STC 217 in case of the appellant very much falls in the net section 2G4 of the OST Act. A meaning given to sale is the transfer of right to use any goods for any purpose, whether or not for specified period for cash, deferred payment, or other valuable consideration. In the present case, there is no dispute that appellant has hired out of machinery to contractor and received consideration for such hiring out transaction through for a limited and specified period. This type of transaction has been judicially recognized as deemed sale in case of transfer of right to use goods. It is delivery of possession to the lessee by the lessor for its use, which has been made taxable. In this case, the ownership is with the lessor, but the possession with the lessee. It is therefore said that lessee is the outcome of the rightful separation of ownership and possession. In order to scrutinize the entire gamut of transaction, it is necessary to see the agreement between the appellant and the contractor. But instead of furnishing the agreement, a copy what is said to be relevant portion, Mukund contractor number 104.1 in the form of except which was furnished before us, from which it is difficult to deduce a firm conclusion. Assuming what is stated before us is correct, the machineries remain in possession with the hirer or lessor for the purpose of executing specified work, and for this the appellant realizes consideration. This consideration cannot escape taxation under the OST Act. Your Lordship, pause for a moment, Your Lordship. Your Lordship, this entire finding, Your Lordship admittedly has the tribunal has come to this finding without sufficient material, Your Lordship, because the petitioner himself, the appellant, could not produce the entire agreement. Everything has not been produced. In no case, Your Lordship, on no ground, Your Lordship. Now, Your Lordship, there have been a good number of instances where transfer of right to use goods have been taxed. Transfer of right to use chairs, tables, carpets, crockery, let out for limited hours of consideration received, therefore, has been held to be taxable 77 STC 470. Where bosses were hired by corporation and the owner of the boss was bound by orders and direction of corporation with regard to journey, timing, and route, and driver was provided by the owner of the boss, it was held that transaction was taxable. Your Lordship, I have submitted that judgment of KC Behra. Where oxygen actylene in cylinders were given to customer for use, the customer held to have physical possession of cylinders and higher charges therefore was taxable 86 STC 539. Where hoarding fastened to structure erected on land required on losses, and it was let out to companies for advertisement rent for letting out was held to be taxable 69 STC 1. Higher charges for meters meant for recording consumption of electricity was held taxable 99 STC 446. Members of video library accessible to cassettes returnable within a short duration and payment was also held taxable 104 STC 498. Branded software like Oracle, Lotus, Meter Keys, when right to their use is transferred, it was held to be sale 105 STC 421. The learned advocate on the strength of the case reported in 77 STC 1 Rashtriya Ispat Nigam Company versus Circle, CTO Circle, submitted that charges received by the appellant in the present case are in the nature of charges received by Rashtriya Ispat Nigam Limited, hence could not be taxed. In that case, Honorable High Court of Andhra Pradesh wrote the agreement between the parties as a whole and found that even though machineries were given on hire to the contractors, the effective control of machineries was with Rashtriya Ispat Nigam, even while the machineries were in use by the contractors to whom it was let out. The function of the contractor was at best as the custodian of the machinery. The Rashtriya Ispat Nigam Limited was in possession and control of the machineries. It is in these circumstances the Honorable High Court of Andhra Pradesh held the charges received were not taxable. The facts and circumstances are altogether different in the present case. As stated above, the agreement was not supplied in its entirety, portion and excerpts from here and there. The agreement was only furnished what we have read therefrom. The contractor in the case on hand was not only in custody but in possession of the machinery. This distinguishes remarkable from Rashtriya Ispat Nigam case and the case law cited could not therefore be made available for its application to the present case. The learned advocate for the appellant also cited the case reported 105 STG 409 Tripura Bus Syndicate versus State of Tripura, when the government of Tripura requisitioned a larger number of vehicles belonging to different operators for election purpose. The owner of the vehicle provided drivers, provided fuel cost. There was no endorsement by use of the government in the respective registration book of the vehicle. No attempt was made to get out of the vehicle, get the vehicles insured under Motor Vehicles Act 1988. These hard facts clearly establish that vehicles at all material times remained under control, supervision, and ownership of the petitioner. There was not a single incidence of transfer of vehicle to the respondent in the state of Tripura. The charges were paid to the owner of the vehicle on the basis of mileage covered, and since there was no transfer of right to use, the charges could not be brought to the net of the taxator. This is not the case before us. As such, it could not be applied to the case on hand. The learned advocate also cited the case of Kandoi Transport Sales Tax Officer 43 STC 167 by the Honorable High Court of Orissa. In this case, the Honorable High Court observed that the intention of the parties, the mode of use, and several other surrounding and relevant aspects were not considered by the assessing officer, and therefore the order of assessment was passed. But the Honorable Court issued direction to the assessing officer to consider whether the transaction of the petitioner involved transfer of right to use and amounted to a sale. This case is not helpful to the appellant. In the absence of, Your Lordship, this is a finding. In the absence of detailed terms and conditions of the contract before us relating to hiring out of the machinery and with the limited materials before us, we proceed to decide the matter, keeping in view of the various cases we have referred to earlier. Supra, in the case, we observed that the machineries have been delivered to the contractors with the operator, through which hardly matters in view of the decision our own High Honorable Court in the case of K.C. Behera, 83 STC 325 for use by the contractors on definite consideration. And the contractor have been legally possessed for such machinery and made entitled to the right to enjoy the goods with control. And therefore, since the substance of right is the enjoyment of goods, transport has materialized upon delivery of the goods. And therefore, we are of the view that the receipt of higher charges by the appellant falls within the ambit of deemed sale as contemplated under Section 2G4 of the OST Act. We therefore do not see any cogent reason to interfere with the finding of the lower forum. The appeal on this court fails. While upholding the assessment relating to the taxability of the receipt of the appellant towards higher charges, we have also taken note of the fact that good number of such cases, the appellant has collected tax from the customers. Yeah, another point he has taken, that the appellant has collected tax from the customers who enjoyed the right to use against the payment. So my respectful submission before Your Lordship that the Learned Tribunal has passed the order, a reasoned order, Your Lordship. And for this reason, Your Lordship, probably for this reason, this Honorable High Court in the first instance has passed without going to the details of the order passed by the Learned Tribunal and confirmed the Honorable Learned Tribunal in the first instance, Your Lordship. And there may not be any reason, Your Lordship, may not interfere because it is a reasoned order in each aspect, Your Lordship. It is a reasoned order, Your Lordship. And the entire portion I have quoted, and also it is covered by that judgment of this Honorable High Court in case of Krishna Chandra Behera, Your Lordship. And so far as the first round is concerned, Your Lordship, nowhere, Your Lordship, may kindly go to the tribunal center order, first appeal as well as tribunal. Nowhere it has been stated that this much we have first point tax-paid goods, this much is the tax-free goods, and this should have been deducted. And for the first time before this Honorable Court, he has taken the ground that this has not been taken into consideration. Your Lordship, let the petitioner shows anywhere that he has disclosed that it is a ground. Your Lordship may kindly turn to the tribunal's ground, Your Lordship. Even what are the grounds before the tribunal, Your Lordship, are taken, and whether that ground is here the question.
We don't go over it again and again, sir. These are all questions of law.
Your Lordship.
Yes. That's it.
Your Lordship, my submission is there.
May I submit, man? Ultimately, the Learned Tribunal has arrived at a conclusion that the matter is a fit case for remit back for fresh assessments. The entire case has been remanded back for the reassessments by the Learned Tribunals.
All right.
Yes.
All right. Orders reserved.
Get free.
Right. Oh, let's stop.